jurisdiction of the Chelmsford Zoning Board of Appeals that are not currently the subject of a pending public hearing before the Zoning Board of Appeals. Public comment on any pending public hearings shall only be heard during such public hearings. So if someone has something to say tonight that is not on the agenda, now is the time. Seeing none, we're going to just give a word on a couple public hearings. The public hearings for 10 Wildwood Street and 13 Stearns Street have been rescheduled due to an omission of the newspaper legal notices for tonight's meeting. A second mail notification was sent to the abutters with the rescheduled meeting dates. A public hearing for 10 Wildwood Street is rescheduled for Thursday, February 9th, 2023. The public hearing for 13 Stearns Street is rescheduled to Thursday, April 6th, 2023. April 6th, good God.
And the year is,
I'm away in March, so it's probably.
Right, and so that was, yeah, we added
year is
another month.
zooming
It just
by.
seems so quick.
soccer season.
We're going to have a little discussion. The proposed zoning bylaw amendments articles for the town meeting with Evan Belansky. Evan, can you walk us through that?
Good evening. So as you may recall, I was attended your meeting of December 1st. We had a discussion, and based upon that discussion, you had asked me to advance some zoning articles to the planning board. So my initial discussion with the planning board took place on January 11th. And then recently, the public hearing opened on January 25th. Between the 11th and the 25th, I believe I had emailed the zoning board, provided you an update, sought your input either individually or as a board. And I think at your last meeting, Becky likely provided an update. So at the planning board meeting of the January 25th, which is when their required zoning public hearing opened, I did present both of these zoning articles. The first one, 198.5, seems to be pretty straightforward. What the planning, so let me present 195-8. You could bring that one up, please.
Yep. Is this the section 2 that was omitted?
Yes.
Okay.
So the first article deals with section 195-8, your pre-existing non-conforming section. And what is proposed in this article is to reinsert item number 2. And as I mentioned to you, this provision was inadvertently deleted when we updated and inserted the sliding historic chart back in 2019. And as the board is aware, what has happened is over time, new commissioners come in, new zoning board members are appointed. I'm not as involved with ZBA matters as I once was, and people forget that Section 2 once existed, and that has caused some confusion at all levels. Section 2, if reinserted, would make it very clear that if Jose cannot issue a by right building permit for a pre-existing non-conforming structure, Section 2 says that it automatically goes to the zoning board for a special permit. That's consistent with MGL, the Zoning Act, Section 6. That provision of the State Zoning Act says that where lots are non-conforming, that's a non-conformity, that's entitled to Section 6 findings and special permits. So that's what provision 2 says. It says, again, if Jose can't issue a by right building permit, you're legally entitled and automatically can go to the zoning board for a special permit. Without that, we've had some confusion where some applicants are told they need to seek a variance. So that's housekeeping as far as
Clarifies
as far as I'm concerned. Correct.
Special permit versus variance.
Correct. So let's move on to the next one, which is 195-9. So in this provision, it deals with the existing 20% reduction that the zoning board can grant. The existing provision 1 is intended to refer to the table of dimensions in the back of the zoning bylaw, not pre-existing non-conforming, but the one that's in the back. So that's why at the end of sentence 1, I added to specifically clarify that the 20% reduction relates to the dimensional requirements in the dimensional table, not 195-8. Then, per our discussion, the board indicated to me that you would like the ability to apply that 20%, up to 20% reduction to 195-8. That's historic sliding scale. So that's what number 2 refers to. Number 3 speaks to the more recent issue with the FAR in the maximum building coverage. In what the board discussed and what I presented and drafted to the planning board was no threshold, but that the zoning board on a case-by-case basis could grant a special permit, based upon the specifics without any maximum not to exceed. So the planning board generally was acceptable, but they did want to hear from the zoning board as to the why and identify any implications. So the why, I explained to them the context of what the zoning board is dealing with, particularly on the FAR and building coverage, that currently the only relief that can be granted is a variance. I explained to the planning board the legal thresholds of a variance, and that I also explained, as I explained to you, kind of the trends that you are seeing pre-COVID, during COVID, and coming out of COVID, where there are many single-family homeowners who are buying modestly sized homes. They have growing families. COVID introduced the notion of living and working in the house. People want dedicated offices. Coming out of COVID, families are growing. People want garages where houses don't have garages. People want to put in sheds where they don't have sheds. And I also explained, and I think the zoning board understands this, it's documented that 80% of our single-family housing lots are undersized, meaning RB requires 40,000 square feet. 80% of those lots are under 40,000 square feet. Some are 30, some are 20, and then in the RC, which is 20,000 square feet, some single families have 10. So you've seen a variety of these situations, and as it pertains to FAR and building coverage, it's come to a head, for a lack of a better word, where that provision is being looked at a bit more closely, with Jose being here, than it has in the past. So the why, I think, is pretty straightforward. One member of the planning board did express a concern in applying the FAR and building coverage special permit to 2 families. So that particular member feels comfortable applying it to single family, but is concerned, I think, in the context that 2 families are primarily a developer-initiated proposition rather than a residential taxpayer. So that member floated the idea of allowing the zoning board all 3 of these options for single family, but potentially either not allowing the FAR and building coverage for 2 family, or putting a cap on 2 families. Maybe it's 20%, maybe it's 30%. Other members, again, want to hear specifically from the zoning board as to what other implications there may be, intended or unintended. That's something that I'm not aware we've discussed, or that you have discussed as a board. So that's the update. The The planning board continues their public hearing next Wednesday, February 8th. They would like to hear from members of the zoning board on the why and any implications. That hearing can be continued until February 22nd. But at that point, the plan, if this is to advance to Springtown meeting, the planning board would need to close the hearing at that point and make a recommendation, primarily because the select board is scheduled to sign the warrant on Monday, the 27th. So the language isn't complicated, but what we like to do procedurally is when the select board signs the warrant, we want that to be language in which all of the boards and committees that are involved in are willing to support a town meeting, as opposed to, well, we'll continue to work out the details between now and town meeting. We don't want any revisions, is the simplest way to say that.
I'm sorry, they're signing the warrant February,
I think it's Monday, the 27th.
okay.
So that's all I have for this evening. I will be there on the 8th. You know, I will continue to assist the zoning board to the best of my ability. But like I said, you know, I think members of the planning board, I think, want to hear and see and hear from the zoning board. I've always presented this as something that has initiated and germinated from the zoning board process.
Did you clarify with them that the difference between the legal ramifications of assigning a variance with a deed as opposed to a special permit, and why we're,
I have.
as far as the
I have. I think
stays
that's
with the
where, I
deed?
think that's where members of the zoning board can provide some real-world context. What is delivered to me, you know, I try not to speak too much on behalf of the zoning board. I think I may have described it as current incarnation of the zoning board is less inclined, if at all inclined, to grant the variance if it doesn't have a legal hardship. And again, that explains some of the historical evolution as to how the zoning board has handled variances over time. I think it's important for the zoning board to try to articulate to the planning board and to the community, you know, the why. We've talked about that this evening. I did provide the planning board the specific case that was in front of you back in January, where Attorney Hausler represented. So I have, the planning board has the numbers for a single family. When the two-family scenario came up at planning board, I quickly rattled off some numbers. RC requires 20,000 square feet. The FAR is 0.2, so you can get 4,000 gross square feet of building area. So I think the zoning board needs to spend some time just to figure out whether, from your experience, seeing new two families being built, whether 4,000 gross square feet is an adequate number, including the garage, the houses themselves, whatever sheds they want to put in the future. That I don't have a good handle on. And then within that context, to one planning board member's concern is whether a cap on the FAR and building coverage, would be workable for two families.
Chairman, do you remember that two-family that we had a few months ago? I think the FAR was the concern. They were
Yeah,
trying to
that
do
has
the
actually been
addition.
continued, I believe, and
Yeah.
that is the one we're trying to,
Yeah.
in a sense, remedy as well as
Is there a way
the
to
future
make a
ones.
stipulation on two-family where it's a owner-occupant two-family? Is there a way?
No, I
They
wouldn't.
change
or-
hands.
We have a couple provisions that speak to owner occupied, is primarily our in-law. I would not recommend introducing ownership
Okay.
requirements. I think the context of a two-family is, an average size garage is 400 square feet.
24 is 576, so
Yeah.
it
so-
adds up quickly. I mean, 4,000
Right,
sounds like a
so
large
then you're left
number.
with a 1,500 square foot unit.
Yeah. I know
that-
they had it, we have a pre-existing that they were trying to make improvements on.
Yeah, that was the one on Third Street, I think.
Yeah, a few months ago. It's
Yeah.
not one,
Remember they wanted to put a
Oh,
garage.
it wasn't
and-
the.
no, it's not the one we
No.
had.
Oh, it was the one
They were
right
trying to
around the corner,
improve the,
yeah.
they're trying to improve the kitchen
Yeah.
and add a
Yeah.
garage,
Yeah.
because they didn't have any, and
And they
improve the
moved the
kitchen.
garage
The
back
two
from the
garages
line.
And they
to
yeah.
tried
accommodate
to,
it.
yeah,
That's what they
because they
ended
had
up
the,
doing.
the
I mean,
fires.
mathematically, that would leave the
Small.
habitable space of about 1,500, 1,600 square feet. I don't know if that's what developers are building for a two-family per unit.
Certainly
Or
would
if,
seem
or if a,
tight.
you know, if up to a 20%, bump.
Which would get you to 4,800, which half of that would be.
Yeah, so maybe that's
2,400.
mathematically a good solution.
I mean, whether the planning board aware that we have the three proofs, if you will? We have to decide with the 1, 2, and 3. Was that explained to them? So if we decide this is okay to do, I think the lot of structure may not be developed without a reduction.
Yes, yeah,
Requirements?
they've seen the findings that are required.
Yeah, so we do have a process, not just
Yep.
whoever comes in any size is going to
Correct.
be acceptable without input. And
Right.
they still had the concern.
Yes, yeah,
I
they
mean, we can
understand that.
Probably talk about this after the meeting, if everyone is up for that, and
Yeah,
try to,
I do think
rather
we
than,
can
you know, we
Yeah, yeah.
can spitball a little, and decide if two families are maybe 20% as opposed to single families. I mean, if the planning board is
Amenable.
sure that's how that's gonna, you know, they'd like to see that.
Yeah, I think the key here is they want to hear from
Some
the
type of
zoning board.
limitation.
That you're aware and understand the proposal, you understand the why, understand any implications, and are you interested in treating single-family and two-family differently?
Right, okay. I don't wanna take up more
No,
of
that's
your
fine.
time tonight.
But you can talk about it later in
I
the
guess
meeting.
If I could ask for clarification, I can come on the 15th, but I wouldn't be there till after 8 o'clock.
This would be the 8th, next Wednesday.
30th?
The 8th. And I
Yeah,
can't,
The planning board is not meeting on the 15th.
yeah, I can't.
That's every other, I'm sorry, okay. I really am stuck till 8 o'clock. What time do they,
If
this
you have,
go on
if
the
you,
agenda
if you have a
as late as
specific,
that?
yeah, we can rearrange the agenda to
my
accommodate.
second question would be, I'm not the only one that needs to go or can go. Is anyone else interested
On
in going?
Wednesday?
And
It's Wednesday, right?
it's Wednesday, the 8th, yeah.
Can we, as long as we can meet later, and, I mean, I'm done.
I mean, do
at
they want input
7:30.
from us? So I was
what it
at
sounds
the
like,
meeting
yes.
for another purpose last week, and they asked for input, and I declined because I didn't really feel comfortable representing the entire board myself,
And
mostly.
the scenario I see is tonight, we would discuss and decide what our
Yeah.
as a board, what we're thinking of whether the two-family makes sense to how we would administrate it, and then with that, if someone wanted to go, I mean, I can be there at 8, but I don't know what time they're gonna put it on the agenda, I don't know if that
We
can
can
be.
put it on anytime.
I mean, is 8 typical? They don't,
We start at 7, but there's plenty of other business to
okay.
take care of.
And I think one person would probably be, like, they don't want to hear from each of us
Correct. They-
individually.
Well, I think if we could do that tonight, we can come to terms on
Yeah.
what we'd
Right.
like to say.
And one to
Yeah,
represent, yeah.
and
I'll
then you
just,
could,
if you can ask them to postpone till 8, and then I can be
Sure.
there, or anyone else would like to attend or speak, it's fine with me too, I'm not,
I think you're the right person.
you think
You're
so?
our chairman.
I didn't think I was the right person. I
ahead,
think you're
Chairman.
probably the right person.
All right,
Okay, thank you.
thank you. Okay, so we'll just take that up later in the,
Wednesday's Girl Scout night.
we're going to move on to our continued public hearing, 150, 152 Dalton Road. Luc Fougere doing business as Fougere Landscaping Incorporated, and 150, 152 Dalton Road LLC. The applicant requests an amendment to the 1955 variance, or in the alternative, a special permit to modify an existing non-conforming use for the continuation of the current mixed use. Yep, that's it. The continuation of the current mixed use as a residential dwelling and a landscape company. The property consists of approximately 1.66 acres located in the residential B district. This is a public hearing. The meeting is still open to the public. I have a letter here that I neglected to put into the record last time we met. And it is from the Luskin family, Jack and Judy Luskin. Dear Mr. Reedy, as abutters of the property at 150, 152 Dalton Road, DBA Fougere Landscaping, we would like to restate our position to the amendment of the variance for the use of the above-named site. We are concerned about possible additional truck traffic in an already heavily traveled area and opposed to the use as now of a contractor's yard in our neighborhood, which could lead to decreased property values of abutters. Sincerely, Jack and Judy Luskin, the Luskin family. And I believe that is the end of the letters that we have to write in. What to do? I think I'm going to open this up to the public, because I think we ended it during that discussion. If anyone in the audience would like to speak in favor or opposition to this, I ask that you hold yourselves to new information or things that have yet to be discussed. Yes, sir.
I'm Henry Day. I have appeared before you a couple of times before on this matter. What I'd like to try to do is, and you have a letter from me,
Yes, sir, we do.
and which pretty much lays it out, and I would like to try to simplify the matter if I can.
I think that would be wonderful.
Because I think actually it is not that complicated. Because if you look at what is going on in the property right now, both the attorney for the applicant and Mr. Haverty all acknowledge that what is happening on that property now is some form of construction yard or commercial activity involving either a contractor's yard or a construction property. And the characteristics of those definitions include things like construction, use by building or landscaping professional, storage of heavy equipment, materials and supplies.
You're quoting from the 2012
Well,
zoning
I'm
bylaw?
putting the two together because I think
Well,
it
I think the
doesn't
timeline is
really.
important, that's why I ask.
Well, I think that either way, what is happening there fits in one or both of those definitions, because none of them are permitted. And that is the point, and that's where I start from. I just add parking of wheeled equipment and so on. What is happening on that property right now is, without any question, something that is not permitted in that zoning district. Okay, whether it's be construction yard, indoor, outdoor, or contractor's yard, almost everything that is happening on that property now, other than the residence, is not permitted as a matter of right in that district. So that, and it has never, those activities have never been permitted in that district. And so that the argument that this activity on this property should be permitted to continue is based on the fact of some prior existing use which became non-conforming in 1977, and it's all based on the fact that Mr. Bennett, back in 1955, had a greenhouse there that he sold. He sold plants that were grown in the greenhouses on that property, and that was all that was going on then. And you see that from the variance that was granted. It was just a variance for him to add a small shop, a small retail store to the front of the small greenhouse that was there. And that continued, and in 1984 he asked for permission to run a maintenance business out of the property, which again just suggests that that's all that was going on there, and he was turned down on the request for that addition to his business. So what was there after 1955, which was permitted on that site, was a greenhouse and a retail store that sold things that were grown on the property. 1977, we have plans that show that there were extensive greenhouses on the property. So, and that's all the information we have as to what was going on that property before 1977, when the contractor's yard, the commercial activity was, and the greenhouse was prohibited. So that if we're going to say that what is going on there now is subject to a special permit to change, alter, or extend a pre-existing non-conforming use, that was the non-conforming use that was there in 1977 when the bylaw was changed. The prior existing non-conforming use on that property in 1977 was a small was greenhouses and the sale of plants. There's no evidence at all that there was any construction activity there. There is no evidence that there was heavy equipment there. There was no evidence that the building materials were stored there. There was no evidence that a landscaping or construction business was being run there. It may have been, but we have nothing to show that it has been, and the applicant has not given us any information to show that before 1977, when the greenhouse was eliminated for a permitted use, that those things had been going on in that property. So, and I show in my letter to you that the burden of proving that there was what was going on in that property before the bylaw was changed falls on the applicant, and we have no information that tells us anything that there was, other than there was a greenhouse and they sold plant materials. So that's really the essence of it, and it makes it a very simple kind of analysis of the situation, but I think because the position of the applicant is so weak on the law, the approach has been to confuse the situation with a great deal of information that is really irrelevant when you analyze it in this manner. And the important thing is to understand that when there is a reference to a pre-existing use, that reference doesn't refer to what was just existing prior to the current owner. Pre-existing means what existed prior to the change in the bylaw, so that is the only thing for you to consider in terms of endorsing the continuation of a prior existing non-conforming use. Pre-existing has nothing to do with what happened after 1977 with the succession of landscaping operations that went on there. For zoning purposes, those were all, to some degree or other, in violation of the zoning bylaw because they were no longer permitted after 1977. So when Mr. Haverty refers to the option that the board might have to grant a permit under 195(8)B, you have to pay attention to the fact that in order for you to apply that, there must have been a pre-existing, and pre-existing means an existing use before the change in the bylaw, pre-existing use that was otherwise permitted there. So I think that's really the simple analysis of the situation. A current use that is not permitted and that could only be permitted if that use had been in effect prior to 1977, which it wasn't. There was a greenhouse there. There was a plant sale, retail business there, and that was it, as far as we know. So I think that really just narrows it down to where, you know, how you have to look at it from a zoning point of view.
Obviously, Mr. Haverty disagrees with you at that point, but I think I would like to hear from the other attorney.
What-
Maybe she can clarify better. It's her battle, if you would.
We wouldn't have a discussion if we didn't disagree.
Absolutely, sir, absolutely.
We would have been finished this
Long ago.
months ago.
Which would have been wonderful.
Right.
I'll feel the same. I think everyone has struggled to understand the complexities of this problem. It really is challenging.
I think it's been made complex because, as I say, that was the only way to approach it, based on the actual provisions of 40A in the zoning bylaw were not very strongly in favor of the applicant. And so then we just get flooded with a great deal of irrelevant information.
Thank you.
Good evening, all. Of course, I disagree. Pam Brown, for the record, representing the applicant Luc Fougere and his wife and their company. It has taken several meetings of reviewing many, many facts, lots of information, history of the site, and the zoning bylaw. I think it's taken a while for us to get to what was the right question to ask, because that's sort of evolved as we've gone through this process. Henry suggested that, you know, it all comes down to one thing, and here really what it is the interpretation of the zoning bylaw as it applies to this particular site and the use of this site over time. The zoning bylaw in Chelmsford and other communities in Massachusetts is first interpreted by your building commissioner or your building inspector. And that's been done many, many times here. Mr. Dane, at one of the early meetings, wanted to go back to 1938, and then it was 1955, and now it's 1977. The reality is that the use, as we said probably at the very first meeting, has evolved over time. What came up at the last meeting where we really left off was, when did this landscape contractor use actually come in as a defined use in town? And the answer to that question is 2012. The position of town council, as well as myself, that's the point in time that we should be looking for, or looking at in terms of what is different between the Fougere use and prior uses. But let me step back. So we've looked back at the initial use of the property, and as Mr. Dane said, we have the greenhouse. This is no small little backyard greenhouse. This was an over 8,000 square foot greenhouse or greenhouses that stayed on the property for quite a long time. There were no definitions that involved landscaping company, landscaping contractor, or anything like that on the books at that time. The building inspector or commissioner's opinions, 4 of them, over time, even when it was a, quote, denial that Mr. Dane has called attention to a couple times, which I'll speak to in a minute, the position even in those denials was, you need a special permit to extend the non-conforming use. We shouldn't need to go back and reinvent the wheel here. You've had 4 separate town staff charged with interpreting the bylaw, looking at the uses of the property, that have done so over and over and over again. We have determined that the 1955 variance is really not relevant to our discussion anymore. Initially, we thought maybe that was something that was important here, but there's no retail proposed on the property, there's no retail ongoing on the property, and if it wasn't abandoned prior to the Fougere residence on the property, it was in 2018 abandoned because he's never had a retail use and doesn't propose one. So we need to stop talking about a 1955 variance. One off the list. We've been informed on multiple occasions by the Chelmsford building inspectors that the prior use was a prior non-conforming use, even a legal use, a use that's allowed to continue without variance or without further permitting, so sometimes so long as it didn't exceed. But it didn't just say the prior use, it said environmental gardens. So the document that keeps coming up as a denial, you may recall, and Chelmsford's one of many towns that does this, before you can come to the zoning board, you need a denial. You need a denial letter from the building inspector. And in 1984, Arthur Bennett requested a lawn maintenance landscaping business, which essentially was denied by the building inspector, indicating it was an extension of a non-conforming use. So in 1984, the building inspector is telling us it's already a prior non-conforming use. Then in 1994, Anthony Zagzug, his determination that the property may be used as a nursery, retail sale of nursery products, and operation of a landscaping business. The operation of the business, however, cannot be increased as to the number and types of trucks or other equipment and suppliers as to the previous occupant Environmental Gardens, which was actually helpful to tie it to something in time that we can relate to. And at our last meeting, we talked, we had an affidavit from Environmental Gardens about the level of intensity in his operations and so forth. In 2012, it appears Anthony built a shed that he didn't get permission to build, but that's not the importance of this letter. This was, in a sense, an enforcement letter about the shed, but it says the records don't show an approval or permit for the increase, alteration, or extension of your existing allowed use. That's Mark Dupel, building commissioner, in 2012. And finally, the one we've focused on many times, it was 2018, after quite a bit of due diligence that the Fougeres performed before purchasing the property to make sure that everything was in order. They went through files, they went through research, everything from the business certificates, but more importantly, the prior file documents, to determine, in writing from the building inspector, Sean Shanahan, that in fact, the use is legal and it could continue. So all of that history, I say, we don't need to reinvent the wheel. We don't need to go back and prove that the 8,000 square feet of greenhouse had trucks coming and going all day long. It's been submitted by town council, and I reiterate that the landscape contractor use can be presumed to be part of the nursery use. We've talked about how uses kind of morph and expand over time. Clearly, the nursery garden centers I'm familiar with, all of them have gone from sort of wholesale to retail to adding, trucks coming in and out, doing off-site landscaping projects, including what we call hardscape, which is your patios and walls and walkways and things like that. So a very natural progression of the use. And it wasn't until 2012 when the town said, we need to pay attention to this new use and put it on the books. And they did. Prior to 2012, contractor's yard was defined very specifically as a building contractor. Talked about fabrication and other things, but it wasn't just contractor's yard, it was a building contractor's yard, omitting any other type, including landscaping. In 2012, that's when landscaping or landscape contractor was added to the bylaw. And it's our position that 2012 is therefore the time we should be looking back to as when the use of the property here became, again, non-conforming, or the expansion of the old non-conforming use is now non-conforming because that particular use has now been specified. So when we look back to when we get to the powers test that we started to talk about at the last meeting, the three-pronged test that the board needs to evaluate to determine if The fougere use is different in kind and intensity and impact and all of those things. We should be comparing either to the prior use or to the use in 2012. Either really works because it was the same tenant or same occupant at the time. In all cases, the occupant of and the operator of the business was also the resident owner of the property. Or in one case, Environmental Gardens, he was a tenant, but he lived there and he operated in the back. It was never bifurcated, so there was never somebody living in the house with a separate business in the rear. It was always part of what I call a mixed use. So I'm happy to answer questions or hear from town council or whatever the board's pleasure. If necessary, I think we're prepared to go back again. I think we did it at the last meeting, so I didn't intend to plan on going through, how many trucks and how many employees. I think we've covered that, but certainly if you've got questions, we're happy to answer.
There was sort of a, if we were approved, just to clarify, I believe, yeah, this is from you, Pam, that if the conditions were allowed to continue or a special permit was decided to be added, that you would agree to no more than 8 non-resident employees. Business work would be restricted to Monday through Friday, 7 a.m. to 5 p.m., Saturday, 8 a.m. to 3 p.m. The geographic area of the site used for business will not be increased. 4, the visual buffers to abutting resident properties shall be maintained by fencing or evergreen vegetation. 5, if a barn is permitted there in the future, 4 outbuildings would be removed. 6, if a special permit is granted, it can be limited to the fougere and affiliated business presently operating on the property. That's what I'm just trying to understand. So if there was a decision by Mr. Fougere to sell, would this cease at that point with the special permit?
Well, I think
I mean,
town
if
council
the permit
advised,
was granted, and there's also the option to decide not to grant a permit, but continue use as, we don't need to grant a permit, and it could continue.
correct.
The third option.
Yeah, so you're correct, and I did submit some findings. So, part of this is we go through the powers test and determine if there's been something that triggers needing to go to the next step, which would be the special permit. The conditions here, I frankly don't know why you couldn't actually impose those on your finding as well, as saying as long as these things are the case, then you're agreeing that it's an allowable expansion or continuation.
Without issuing the permit.
Yeah, so, but in terms of the user, a variance runs with the land. A special permit will, but you do have the authority on a special permit to condition it. Sometimes I see restaurants that are.
To the owner.
To the owner. I want to be clear, if Luke has, his son grows up and wants to continue the business, we want to allow them to do so. But if it was sold, if the property was sold to a third party, I mean, right now, the concern is the family bought this property 4 years ago, to raise their family and operate a home business. And that's the goal.
My question is for the number 2 condition, how would that impact your snow removal process in the wintertime?
Number 2.
With the hours, Monday
So-
through Friday, 7 to 5?
I guess I think it was a board member at one of the last meetings has sort of taken emergency services sort of out of the standard business work. Because, they're not obviously operating when there's no snow, but when there's snow emergencies, it kind of is what it is.
I don't think it was considered snow emergencies by the butters. I mean, going to your customers to plow their driveways during because that's the paid service. Emergencies not
But
getting.
it doesn't happen on site.
No,
So
no, no.
If a storm is coming,
But I know the butters'
they
concern
would
was
be,
that
the
trucks
way this
coming
is
in and
written,
out.
they
to
would be
get
responsible
salt.
to have the trucks equipped and out before 5 p.m. Monday through Friday.
But not loading up and moving before 7 a.m.?
Correct, but they're plowing snow, they're not loading snow.
Right, I'm saying. But like salt and
Yeah, the loading.
firing, that's what I'm saying. The biggest concern has been the moving of trucks and such, right? Firing up the trucks and such, 7
Is-
a.m., all
is
the
salt
loud
stored on the
noise.
property?
Yeah, I have a small salt bin, yeah.
That's what,
Well, it's a concern, you're absolutely right.
Yeah,
so,
so if it
and when
starts
they have
snowing at
snot
10 o'clock at
removing,
night,
or
are they
they've gotta
gonna be-
plow their customers' driveways by 4 because their customers have to get to work by 6 or get on the road to beat traffic, you know what I mean? I'm just,
Well, I'm hearing you. I'm a little challenged by it because really most of the noise is wherever you're plowing, not really
well, I'm
starting a
just,
truck and leaving.
just going on what the abutters expressed in
Yep.
the last two sessions.
It's funny that we didn't hear that in the last 30 years, but
I know. Hey, I'm just, again, the.
same with the chainsaws and,
Yep.
you know, but
Yep.
we're here.
Yep.
So
We
we
are.
need to deal with
Yeah, but
what's here.
that's like his business every other day. All they're doing there
I know.
at that site is loading.
But I'm
the
just saying,
truck.
he's
All
saying-
the business is
he's
always
just
done
saying-
off, whether it's snow or it's landscaping.
But he's saying he's gonna restrict the movement of his
I
vehicles
understand
till
what you're
7.
saying, but yeah, you're.
But snow removal, he wouldn't be able, I mean, in
The argument that
essence,
he
to do
removes
snow removal, he wouldn't be
I
able
mean,
to
ideally,
restrict
we
his
would
movement before 7.
exempt the snow removal function from this. I mean, this was intended to be the landscaping business, but
I would hate to see him limit himself to 7 AM, no movement before 7 AM, when and if you have snow removal, you obviously need to move before 7 AM.
it's not an issue for this board so much, but one of the reasons he was looking for the garage, the barn, was because the salt could be stored in there. The salt has to go on trucks and stay warm enough, I guess, right? So that it doesn't freeze up in a
Yeah.
block. And I think actually just before the last meeting, that's what was happening. It was just very coincidental because it wasn't typical operation, but because the salt bin is outside on the side yard rather than in a building, it just, you know, if it could be loaded early and the truck can park in the barn, then it would have made life easier for everybody, but for another day.
I mean, I feel like I would disagree with that. For a lot of landscaping companies, I think snow removal is
Oh, you wanna
typical
stand next
operation in the wintertime.
Well, I would think that we could amend to exclude snow removal. I think that's a reasonable request.
That's what I'm
I
saying,
mean,
I just
typically
don't.
during snowstorms,
I'd
there is
hate to
not
s-
a lot of
hate to see
noise
you
because the
put that
snow is such a
there and-
dampener. It really
Well,
quiets
then,
it.
I mean, the phrase business work restricted to Monday to Friday, 7 AM to 5 PM, Saturday, 8 to 3 would not be accurate in that case. I mean, you know what I mean?
Excluding snow events. I think we could put in there if we feel comfortable with that. If it's not,
Yeah, we don't
then we
deny
can go to more discussion. I mean, that's a small detail, but it's important, I think. The idea is to make it work so everyone is going where they belong. Are there
But we
further
still need-
questions as to the 6 items, or?
I could answer that hours question briefly. It might help.
Okay.
We prepare everything during business hours. So during the allotted hours of which we're allowed to operate, we prepare to the furthest possible extent. And it's literally start a truck, leave.
So you load the trucks and everything and have them ready to go?
I load the truck, we put the plows on, we do all the clanging and clanking or whatever somebody may consider a little disturbing during business hours. We park the trucks halfway to the street, and then we start them and we leave. So,
They would come back for additional salt.
I mean, it seldom. It really depends on the storm. I mean, when we first moved there, it was crazy. We went through tons and tons, and then, like for example, this year, not that much.
But-
So
but
we've
it's
had the ability
been a
to.
couple of years.
Yeah, please, honestly, I'm 19th year doing that, so. But yeah, we to the absolute furthest extent, load, grab a truck and leave. I mean, I've got 9 weather apps on my phone, literally. So I try to stay on top of it as much as possible so that any other disturbances are void. Just wanted to answer that briefly. Thank you.
Any other items of concern on the list?
Hey, Brian, I just wanted to know, I know we can deny it, we can approve it, we can do whatever, but Pam, did you say something about that we could just do nothing and just keep it going as it is? Is that what you meant?
No.
Can you explain that?
We gotta do the powers test.
Wouldn't that be easy, huh?
Yeah, that's what I thought.
No, sorry. The first order, and it may make sense for town council to review his letter because he did a nice job presenting it, but the powers test, and the
Yes.
powers was just a
Right.
court case that people still use today in evaluating how you look at changes expansions of nonconforming uses. And it's a three-pronged test. So if you go through that test, which I actually had in my minutes from the last meeting, we talked a little bit about it. The board needs to determine, for example, is the present use in keeping with I'm trying to remember the exact words, but the nature, the nature, and the intensity, essentially. The third prong is more about the impacts on the neighborhood. The real question at that time, and I think it's when we sort of stopped the meeting and said, let's find out which point in time in the bylaw we should be talking about, which we're really now saying is 2012. Not 1955 or 1977. Because we need to know what we're comparing to, right, when we're talking about an expansion or a modification of a prior non-conforming use. So my suggestion was either you can make findings. I had proposed some for your consideration in my letter, which I can walk through if I can find my letter. And really, I just put those out there to kind of give a starting point for the board's consideration. If you can get through that list, anybody have my letter? Thank you. And would you like me to walk through this? I can certainly do that. But bottom line is, if you can walk through this without sort of triggering any of the three, you have to be able to satisfy each of the three criteria. Then you're simply making findings that the use is an allowable modification that doesn't rise to the level where it's a significant expansion or modification. If it is, then you go off to the special permit test under the bylaw to evaluate under the special permit criteria. So the first is really a series of findings, and if these findings are satisfied, then essentially you're making a finding that the use is allowed to continue. Doing nothing doesn't do that, though. You actually would need to make the findings. What I was suggesting is that you make some simple findings as to the facts that help set the stage. That the extension of the nursery greenhouse retail use to encompass a landscape contractor's yard prior to the 2012 zoning that prohibited a landscape contractor's use in a residential district was a permissible change. And that was what was discussed at the last meeting, is that this use was added, if not sooner, by 1984 and has continued ever since. So that use, it was suggested at the last meeting and today that use was really an extension of the nursery business. And as I said earlier, I mean, nursery garden centers have really kind of moved in this direction to add all of these uses. So that's logical. And it wasn't until later in time that it became enough and probably common enough that the town decided you really needed to define it in the bylaws. The second suggested finding dealt with the finding that the 2012 zoning bylaw is the operative date for determination of whether the current and proposed use of the property is an extension of the prior nonconforming use. And then as for, this one's really brief, I probably provided more detail in the last meeting's summary, but in number 3, the 3 items here are what's responsive to the 3 parts of the powers test. So one was suggesting that you find that the Fougères' use of the property is consistent with the nature and use prevailing in 2012, in particular a mixed residential landscape contractor's yard, substantially similar to the uses conducted by both Environmental Gardens and Anthony's Gardens prior to 2012 and continuing through present. The second prong is to look at the similarity of the business, the extent of the property used for the landscape contractor's yard, the number of vehicles, again, we talked about this at the last meeting, number of vehicles, number of employees, and that there's no difference in the quality, character, or degree, again, as compared to the prior two landscape contractor uses. And then finally, as compared to the use in 2012, the present use involves similar or fewer trucks, equipment, hours and days of operation, deliveries to the site. And then I'd also note that clients don't come to the site here. They did in some of the prior users. They were selling loam or selling firewood or whatever. But Luke does not have clients coming to the site. And there's, as we said earlier, no retail activity. Again, just food for thought for your discussion. But if you were to make these findings, then you would simply be saying, we've made these findings, and therefore the Fougere landscaping use is permitted to continue. If you think for some reason that we can't satisfy these tests in something, you know, say for example, he has a lot more trucks or bigger trucks or whatever, if the facts don't show that to be the case, but if you were triggering one of these, then you would move on to the special permit evaluation. Jonathan can chime in on that one probably.
Thanks.
If you'd like to speak to this, I know that Mr. Haverty spent a lot of time on it.
Sure. I mean, mainly I want to be here to answer any questions the board has, but I think the summary of the law, I don't think either council is disagreeing as to what the law is. So there are a few determinations the board needs to make. Number one is what's happening there, a pre-existing non-conforming use. If so, at what time did it become pre-existing non-conforming? Has the use, or has the pre-existing non-conforming use been quote-unquote altered or extended under that powers test? And we can talk more about that if the board wants to. And if it has, then the question is, does the board want to issue a special permit? I'll note that the special permit for extension of a pre-existing non-conforming use is really a one-part inquiry. You don't necessarily go and look at your normal special permit criteria. The one inquiry that the board would need to make in that instance is whether the current use is substantially more detrimental to the neighborhood than what you consider to be the
proposed.
pre-existing non-conforming use. So those are sort of the steps you need to walk through. I'm happy to elaborate on any of them as it would help the board.
I guess my confusion is if we choose what seems the straighter path to just say things are as they are and they don't need to change, if that is done, and we'll have that discussion. But could we put any restriction on it as proposed by Ms. Brown?
So it's interesting. I always tell boards that any condition is valid if there's no appeal, right? So if an applicant is saying to
So
you,
choose to, we can, without a special permit, say this is what we'll do and these are the conditions and.
but
let
to
the
be a
chips
little
fall
less
where
glib
they-
about it, you know, the application to you was to amend a variance. I would note, though,
But there's, I think we're all in agreement, there's no longer a variance.
right. But so what I'm saying is, it wasn't styled as an appeal, but there is case law that indicates that if someone files an application within the appeal deadline, that the court can treat it as an appeal. So just procedurally, I wanted to put that out there. This application, I just checked, I believe was filed on the 30th day, 31st, but the 30th was a Sunday. So if the board wanted to treat this application as an appeal, I think everyone has been on notice as to what the end result is that the applicant is seeking. I think you could do that, so I just wanted to mention that from a procedural standpoint. If you treat it as an appeal and you decide to overturn the determination of the building inspector that zoning relief is needed, the question is, well, how do you impose conditions? The statute says you essentially step into the shoes of the official whose decision you're being asked to overturn. So this board would step into the role of building
inspector.
official, and certainly building officials put conditions on occupancy permits, building permits, and the like. And I think the way you would style it is that, and we can certainly help draft a decision if this is the way the board chooses to go, that the board made a determination that the use within these parameters constitutes a pre-existing non-conforming use and has not doesn't constitute an extension of the pre-existing non-conforming use. However, if any of the following,
It would constitute a violation
then we
of the-
find it would, and the applicant has acknowledged that it would. And I think that's the way that it would.
Basically, a gentleman's agreement at that point.
Well, I mean, it would be memorialized in writing, and at that point, if the applicant and I don't think this would happen, but if the applicant disagreed with that, they would need to appeal.
If I could just add to that, when I've actually represented.
If I could just have the microphone.
Oh, I'm sorry. I was just going to suggest, sometimes boards just make conditions that would make you happy, and if it doesn't sit with the applicant, then they potentially would appeal. Here, where we've actually proposed some conditions that might make this more palatable, we're essentially offering them to you, so it wouldn't, I mean, our grounds for appeal is a lot less when we've offered them.
An agreement is so, as opposed to
Right,
imposed.
right. So, anyway, I just wanted to make it
It's a
clear.
new area for us, for sure. This is all a little unusual.
Are the building commissioner's previous acknowledgements of the use legally binding?
So they would be legally binding on the people to whom they were issued, meaning the prior property owners. So a prior property owner couldn't come back more than 30 days after a determination that you need a special permit to expand a pre-existing non-conforming use and say, no, we don't.
But at the time, they're considered a legal, it's a legal right of this person to use this property this way based on the building commissioner's decision.
I think really what you can treat it as is historic evidence of the way that the use has been treated and considered under zoning.
Okay.
And so particularly when it's difficult sometimes, when a use continues or some form of a use continues for decades, and after 50, 60, 70 years, someone says, well, actually that wasn't legal when it started, it's sometimes hard to find evidence to meet the burden, and certainly Attorney Dane's correct that the burden is always on the property owner to prove pre-existing non-conforming use protection. But I do think that the board can consider official records of the town
Evidence.
in making the determination about whether that burden's been met.
Okay.
Any further questions this time? Seeing none, I think I'll open it up to public comment, if there is any. I just ask for your name and address, ma'am.
Sorry, I'm a little dizzy tonight. Vertigo.
Oh, I'm sorry for that.
Not fun. Nancy Arroway, 65 Littleton Road. I guess I just wanted to throw a little more shit in the works. And point
I
out.
did read your letter,
You
incidentally.
did, yeah, thank you. So what I wanted to point out here is that we're really talking here about the difference between non-conforming and pre-existing non-conforming. So we had pre-existing non-conforming when we had a nursery there that had been sanctioned by the building commissioner, a nursery, maintenance, whatever. But there's a difference between nursery maintenance that involves a whole lot of plants and hardscaping that doesn't. So even if we look back at the 1977 bylaws, contractor yard doesn't cover, the definition of contractor yard doesn't cover landscaping. But if you look at the definition of warehouse and open storage, it's the storage of bulk goods and products, whether indoors or out, for distribution but not for sale on the premises. And that's what they're doing here today. Somewhere in between the building inspector's sanctioning of nursery and nursery maintenance and what we have today, there was a transition from that pre-existing non-conforming sanctioned use to what is today a non-conforming industrial use. So you're not really in the same ballpark here in terms of extending the usage definition from a nursery to hardscaping. What you're really looking at is, do you want to provide a use waiver for an industrial use in a residential area? And if they were coming to you new for this type and this size of a home business in that location, would you consider it appropriate?
I understand what you're saying, but they have a right when it's not a law, and then in 2012 became one. And I think to your exact point, people looked back and said, we have a problem. We haven't included landscaping as part of this design. We need to. And in 2012, they made that decision where hardscaping has grown to.
Was this a landscaping service in 2012, or was it a hardscaping? Because if it was hardscaping, it was still under that warehouse and open storage definition. They were,
The
they were,
building inspector
they would
didn't
have been,
consider that to be the case.
that was in 80-something, right? That they actually had plants there and they were doing plant maintenance. What were they doing there in 2012?
Well,
or at the
if
transition?
was
Had it already gone to
before
hardscaping?
2011, they could, because the town changed the law to include landscaping. So I think they felt there was a hole or a void that people were continuing to do this hardscaping or landscaping on their properties because they weren't held to that. And then they said, well, let's fix the law, which is much what we did earlier tonight with the FAR and the area, where we try to adjust it to changing times and keeping things as they should. But you can't go behind the law and say, well, now we've changed it, so you can't do what you've done.
No, you're missing the point.
I'm sorry, okay, try
I
again.
think
Yeah.
what she's
Let
trying
me-
to say is that if there's no plants, how can it be landscaping?
That's right.
It's just hardscaping.
It's just hardscaping.
not landscaping
If there's
anymore
no
once there's
plants
no
there in
plants.
2012, it was
Which falls
just
into that.
hardscaping. In which case, they had transitioned their business to the definition of warehouse and open storage without going through any kind of an approval to make that transition to an industrial use.
If I could, do you do landscaping as well? When you put up a wall, you put up a cement border, but the landscaping is also part of your job?
Called Fougere Landscaping, Inc.
Do you do plants?
We
Do you do
absolutely,
trees,
yeah.
and where do you get them from? From
All
another,
over the
another
place, and we
provider?
do grow in our greenhouse as well.
Oh, you do
we
grow
just
in,
don't
you do grow
retail.
in your greenhouse
That's all,
also.
we just don't retail. I've been using that greenhouse since we moved in.
So you do
I
have a
was under the
greenhouse there and you
impression
are
that
growing
Fougere
there?
Landscaping
I mean,
did
right
So
now
you're
it's
still a nursery?
20 degrees.
Oh, I
so-
get that. So I'm hoping mine's not.
You don't retail in the essence of what they previously do, but you technically do sell the plants you grow
installing them,
in
yeah, of
your
course.
business, but yeah. So they do
And they
grow.
install the
They
bushes.
sell,
pre-existing.
Yeah, yeah.
Once the
Yeah.
wall is complete, they complete the landscaping.
Or not even built a
Then-
wall.
then
You
you've
still
got a
do lands and
pre-existing
yards
use.
without wall building.
Yes.
That's my opinion as well,
Yeah.
but yes, okay.
Yeah, I mean, if there's still plant materials there and it's still a nursery, then it continues to be, it was acceptable, pre-acceptable. And at that point, I'm good.
Thank you for your
Shuffle my way
time.
out.
I hope you're feeling better. Is she okay?
Vertigo's getting her good.
Yeah, that's tricky. Would anyone else care to speak in favor or opposition to this application at this time?
Ready to close?
I was, if this gentleman stood.
Oh.
Larry Thatcher, 77 Linwood Street, and you've heard from me before. This has been a convoluted case before you, and really digging back through the nuances of zoning law and case law, there are things that are very confusing. One, I look at the law somewhat differently than counsel sometimes, and I look at it and I say that the nursery and greenhouses that constituted Bennett's operations were an agricultural exemption that exists then and exists today as a farm less than 5 acres. And so, and that has continued since the inception of Bennett's Nursery. So I have a hard time listening to the arguments about what was a prior existing non-conforming use. I don't see it as that as a non-conforming use. So when I look at it, I don't see that you have any options whatsoever to consider a prior existing non-conforming use. And as far as the definition of a contractor's yard, the old definition called it a building contractor. Building was not capitalized. In other words, it didn't tie itself to a definition. And I look at a hardscape contractor as a building contractor. You're building walls, you're building walkways, you're storing materials. So we have a hybrid of either a contractor's yard of any definition, as well as what we were just listening to here a moment ago for storage of materials outside. So I think you're confronted with a lot of various issues here. It's not easy, and I hope and I urge the board to very thoughtfully consider the statutes and the case law, particularly as presented by my counsel, Henry Dane. And I hope that you find that the applicant fails the powers test, as well as other aspects find in opposition to the applicant. I'm a small business owner. I don't begrudge Mr. Fougere the desire of making a living. I do not oppose that he manages businesses from his residence, but do so with the provisions that his Dalton Road operations are limited to those provisions published in the Chelmsford bylaws for home occupation as of right. Not all of these other conditions which go well beyond what we accept as a home occupation. I thank you for your consideration. This is not an easy task for you.
I'm certain it has been.
Would the nonconformity be considered the the business in an RB district? Because it was granted to have the business in an RB district?
Yes,
So that is
that
the
is the
nonconformity.
nonconformity.
So there is a nonconformity, because it is a business in an RB district.
Correct.
So would that
Okay.
be when it became pre-existing non-conforming?
The granting of the
Because that's-
business and then
Well,
the
then that's
RB.
way back. You're talking 19.
I don't think the date is relevant. It's, the nonconformity is it was granted to have a business in an RB district.
But the powers
my-
test, the first thing in the powers
Well,
test.
the powers
is-
test, yeah. Yeah.
So
I think there's other aspects of the power test we need to look at as well, but there is in
that's a
fact.
huge, because that's the
Yeah.
first thing, because if it did become pre-existing non-conforming, I mean.
77
The
or-
lawyers is suggesting that it was 2012, but if it was 1955, then
So
it's a
the-
very different.
In
date. So
2012, a
It's
simple
the
change was
type
made to the
of
zoning
business.
that
Came to the
accounts
type
to
of
this.
business. From nursery to landscaping was the
It
2012
was-
date.
So I
But the
think,
nonconformity purpose of the property was being granted to operate a business in an RB district, is what I was trying to get clarification of. And then 77, it was given that permission
In 2012, the change that was made was,
to the zoning laws
Yeah.
as far
it was
as.
changed, implies that a building contractor or subcontractor for storage of equipment and supplies, fabrication of subassemblies, and parking of wheeled equipment. This definition clearly does not include landscaping contractor yards, which explains why the zoning board made the change, or the town actually made the change.
But at the time, there was already that equipment being stored on that property because environmental was running a landscaping business.
So before they were allowed to, once the law they became a non-conforming, but they are grandfathered by the right to do that.
Can I
You can't
point one thing
back
out
up a law.
on that particular
Okay.
issue? If the bylaw was changed in order to make
Then
illegal something that he was doing on the property, why should he then be able to benefit from the
We
fact
don't- we don't
that
know it was
it-
on this property specifically.
No, but it did affect his property.
It did.
And then that is what you're saying, what gave rise to the nonconformity, and therefore he is entitled to get a special permit to do what he had been doing before that would not have happened if you had made it illegal to do what he was already doing. It doesn't make any sense, because what you're saying is the previous bylaw did not prohibit landscaping. And then there was a sense that should not be carried on that property. And so
Not
the
on that
town
property,
changed
on any
all,
property in
but
town.
including
But
that
I think it's the
property.
creation of that, and once you have it, they cannot remove it without.
But what you're saying is that by your making it illegal at that point, he then has the benefit of getting a permit to continue what he was doing before. So
I don't think he needs a permit to do that. I
It
think he just
wasn't
gets to
illegal
continue.
before. It wasn't
would
illegal
need a-
before. Yeah.
I understand what you're saying, and it's wonderful. You could say we'll go back behind the law, before the law is created, because you're doing what the town would rather you didn't. But that's not the town's right. The law was not created.
Well, but it did become essentially non-conforming back in 1977. It just became more non-conforming in 2012. So
Why did they need to make the change if it was non-conforming, and said, why
because they
why did the
didn't
law have
because
to be changed?
because the town did not want him or anybody else to be doing in a residential district what he was doing, and now what essentially is you're
Still-
bootstrapping that.
Gets those rights.
But you're saying he can do more than he could have done before you made it illegal.
Well, that's what the powers test should determine, but
But
I don't know.
But the
haven't-
powers
we haven't
test,
applied the
also the
powers
most
test yet. I
important
was just
thing
trying to-
in the powers test is it more detrimental to the neighborhood? And if you look at the pictures as to
Haven't-
what,
Yeah, I don't think we've done the power, we haven't discussed the powers
if you've looked
test.
at
We have to
the,
get through steps
board.
1
Yeah.
and 2 before we
Yeah.
get
but
to
it's
your
not just the
point,
powers
yeah.
test, but it's also in the bylaw and in in chapter 40A, the most important thing after you determine that there has been a change is whether or not the change is more detrimental than what was there when it was conforming. And if you look at the pictures and compare what has happened on that property, and particularly the picture that I attached to my letter, which was something that was taken in
have them
December, color picture, the last page in my letter, and you look at that and you say,
So is that accurate? So when we determine if it's substantially more detrimental, are we comparing now to when it was conforming, or are we comparing now to when it became pre-existing?
well, I would say that it is more detrimental than when it was a conforming use.
But are we,
which-
is that what we're doing with the powers test? Are we
I think
supposed
we'd
to be
have to-
comparing now to when it was conforming, or to when it became pre-existing non-conforming?
Doesn't it have to be by ownership?
You're comparing it to when the pre-existing non-conforming use was altered to the extent where you find
Currents now.
yes on all three factors of the powers test. So
So not the conforming time. So we're not comparing it
it
to when
might,
it was conforming.
in some instances it might be, in some instances it might not be. So the law recognizes that over time, pre-existing non-conforming uses will change with the times. And so where a pre-existing non-conforming gas station in the 50s probably didn't sell a whole lot besides maybe motor oil, the courts will recognize that selling candy and packaged foods and things like that is a legitimate extension, changing with the times. That's what gas stations do now.
That's a good
If
analogy.
you're now going to add a Dunkin' Donuts drive-through, that could legitimately be considered an expansion of the non-conforming use. And then you would look at that and say, is that going to be substantially more detrimental to the neighborhood?
So would you look at the drive-through, or would you look at, which point would you be comparing to?
So in that example, let's say over time they started, they added a little shack to sell milk, and then over time it sort of grew. You're going to look at what point in time are we now tipping the scales under the powers test, where this is no longer just changing with the times, it's now an alteration of the pre-existing non-conforming use that requires the special permit. And at that point, you would look at whether that tipping of the scales is gonna be substantially more.
So we would look at the first step in the powers test, use that same date, basically.
But the
For this,
the
when it became
last
pre-existing
time,
non-conforming,
the
would be
last
basis for
time that the
comparison. If you're gonna do the
property-
powers test, you start with that date on number one, when it became pre-existing non-conforming, we determine that. And that is the date that we would go back to for number three to compare to.
and the last time it was conforming was when it was in
The
Bennett.
last time it became conforming, right. And so that, then you're gonna look at, well,
We're looking at.
let's look at nurseries. I think part of your inquiry is, okay, a nursery was an allowed use. What is part and parcel of a nursery going back to 1976?
confirm Anthony was conforming?
Did it include things like equipment and, some of these other things? And so, as of 1977, was it still conforming? Did it not become non-conforming until nurseries were no longer allowed in this district?
Which is 2012. But landscaping is 2012.
Personally, I don't feel like we're gonna get anywhere until we figure out the date of comparison. Because I hear 55, 77, 84,
I think we should just get down to the
2012.
powers test
Can I,
and try
yeah,
and
can I,
work it out
I'd like
one
to,
by one.
yeah, because,
I'm of the opinion, based on Mr. Haverty's reading, that on 2012, landscaping,
Anthony's, not Anthony's.
Environmental.
Anthony's?
there was environmental gardens at
Who
that
was the
time.
previous, you bought from Anthony's, right?
But after 1977, it was always non-conforming. The last time it was conforming was when it was a greenhouse
Yeah, you had a letter from. the
Which was
building
then
inspector saying they
prohibited.
were compliance.
in 1977.
Okay.
But subsequently to that, everything has been non-conforming
Right.
all along. It has just become more non-conforming as time has gone on.
Okay, in compliance is non-conforming then.
But isn't that debated? Because then is it an extension of the current use?
Yeah.
The
If Anthony's,
1977 bylaw does not include landscaping contractor yards.
Right.
In 2012, the zoning law changed to include them.
Right.
That is when I think it became technically non-conforming. If
Well, then
if
let that-
landscaping
have a
contractor
landscape-
don't we
yard
have
is
to make
not
that
in the zoning,
determination?
and it was allowed by, at that time, 3 separate building inspectors.
Yeah, but but 1955, they issued a variance. That
But
alone
the
would
va-
make it
it's out, it doesn't matter.
That
It was
doesn't
for a
apply.
retail
That's not-
store. So
it
the
doesn't-
variance is
it's-
no longer a
that's-
factor in our decision.
But wouldn't that make the lot non-conforming
no, because
automatically? I mean,
because the retail shop is dissipated.
Once it
no-
closed for a period of
once it-
extending 2 years, which we don't know if it closed at all until we know in 2018,
from it.
Mr. Fougere bought it and has not sold retail. So that variance
no longer-
becomes,
it null and void.
it's done. It doesn't exist anymore for arguments. He couldn't open a retail store now on that variance because of the 2-year lapse.
Yep. But that
Abandoned.
doesn't say that it was not non-conforming in 1980 if it had a retail store,
It could have had a retail store in 1980.
and it would have been non-conforming at
Could I
that
jump in
point.
for a second?
Please do.
Sorry, not to
Thank
make
you.
Yeah,
it,
no, I would appreciate clarity.
not to make it
So
more
fantastic.
complicated. So I think we want to treat separately issues of nonconformity and issues relating to the retail store. So the retail store, we don't actually have a lot of information about it. At the time, the 1955 bylaw allowed you to sell plants on premises. No variance would have been required for that. It's a little hard to know. The bylaw at that time said that the store had to be at least 50 feet setback from the road. We don't know if it was. One of the plans I saw showed a shop pretty close to the road. I don't know if that meant shop to work on things or shop where they used to sell stuff. And the variance, as I recall, I don't have it up in front of me, referred to selling garden supplies and other things. That wouldn't have fallen within the allowed use for nurseries of selling plants, so maybe that's why they needed the variance. It's a little hard to know because the records aren't.
It's very
you know.
limited wording, even in the variance.
Either way, though, I don't think we need to really give that a lot of thought, because if they were operating pursuant to a variance, that doesn't make it pre-existing non-conforming. That makes it, you know, non-compliant operating pursuant to a variance. It's a different animal. So you can't then, if you're operating pursuant to a use variance, you can't bootstrap and say, well, I want to change to some other non-conforming use. It's two different paths. So I think we can just put that aside. The question is, back in 55, nurseries were allowed in this zone. In 77, it doesn't seem, I'm looking at the, it talks about farms of under 5 acres were allowed, so maybe you would still consider it a farm. I should note now, the bylaw only, it tracks Section 3 of Chapter 40A, which only allows, only exempts farm uses of certain size, basically over 2 acres or 5 acres, depending on the profitability. This property, as I understand it, is under 2 acres. So
Correct.
this would never have been an exempt Section 3 farm.
Agricultural farm.
Because it doesn't have the, and I note that that statute was changed a number of years ago. It always used to be 5 acres or more. So I think we can put aside any question about, well, this was never pre-existing non-conforming. It clearly is, and building officials found it to be over the years prior to 2012. I think the 2012 inquiry is at what, if this is, if the pre-existing non-conforming use is nursery, and nursery was always understood to include, certain types of equipment and things, which I think we can agree it was. At what point was a nursery no longer allowed? And at what point could you no longer presume that the type use of equipment on the premises couldn't fall within nursery? It would now be considered something else. And so I think what Paul's letter is saying is, it's for the first time in 2012 that the town said, landscapers, it's all well and good if you're growing plants on the premises, but as of 2012, if the predominant thing you're doing is storing and equipment and materials for off-site use, even if it's ancillary to also growing plant materials, that's now its own use and no longer should be considered as part and parcel of, say, a nursery. So I think that's where Paul was giving the opinion that the board could find that you had a pre-existing nursery use all along. At least from 77 forward. At what point is the other components of this business becoming something that isn't considered part of a nursery use? And that's 2012.
Right. And after that point, they would be, by right, allowed to continue, even though they're non-conforming. You
If
can't-
they're not extending the use under the powers test.
Right. So I would suggest, if there are no more questions, and I see Nancy up there probably has some statement, we'll hear that and then consider examining the powers test as applies to this lot.
Thank you, Mr. Chair. What I wanted to point out is that in the beginning, when this greenhouse was established, it was an acceptable use, and the sales on site was the permit that was attached to it. Today, it would be an acceptable use under agriculture within residential districts. So we have several categories in our zoning bylaws in terms of our use table for exempt agriculture and non-exempt agriculture. And this would be non-exempt because it's not 2 acres or more. Exempt is covered by 40A, and that's the other piece. But the greenhouse would be an acceptable use today. So then you had that off the table, because we don't have the greenhouse anymore. It's just not something we're considering. But we do have the question of a nursery use that at some point the building inspector acknowledged and accepted, and the differentiation between a nursery and a landscaping business. So if you look at a nursery, again, it's agriculture, it's commercial agriculture. So Mahoney's is a nursery. They have trucks, they do installations, but they're not in the landscaping business. Look at Weston Nurseries down
Pine
off
Hill
110, yeah. They're in this business of selling plants, raising and selling plants. They have trucks, they do installations. They are not in the landscaping business. What we have here is a landscaping business. It buys in and installs plants for a job, but it's not in the business, it's not in the plant business. It's not the agriculture business, it's the hardscape business. So you really need to look at, when did you have a transition between the nursery business and the landscaping business as your point of definition of when did your nonconformance start? Does that make sense?
Yeah, I think it doesn't answer itself very well.
And I don't know
but
the answer to
question
that.
is there.
I mean, I don't know when it stopped being a nursery business and when it became a landscaping business.
I think the
I
analogy
think that's
that the
the-
attorney put out of
Yeah.
a gas station that now sells milk is very valid
Yeah.
in this case. If you had, you're selling corn or whatever it is, or even not a vegetable but a plant, and that's going on, and bit by bit, you're selling pots to go with them, and then the next thing
Yeah.
you know, you're selling fertilizer going in the pots, and it's the
And there's
natural
the,
growth
which
of
is
a
the
business.
accessory and which is the primary.
Correct.
Yeah.
And I don't think that's the,
And I think that's what you have here is, because you're jumping from an agricultural business to an industrial business. And
jumping
you-
over
you gotta
70
figure-
years, but yes.
somewhere in there, it jumped.
Correct, right.
And
It
the
it still
question is
falls
where?
that this gentleman has
Yeah.
a piece of land that has been detailed by 3 separate building inspectors to be in compliance and able to operate, and that, to me,
As a
carries a lot
landscaping,
of weight.
as a nursery business, right?
Several different
Or
ways.
was it as a landscaping
That's
business?
not a nurse, that's not a.
I mean,
This is pretty
Yeah.
evidence, clear pictures that it was run as a contractor's yard, a tree yard,
Yeah.
landscaping.
Is that environmental?
Yeah, that's
Well, yeah, and
environmental,
it's-
the
Yeah, I
exhibits that
don't
were
think that the
presented.
change came when Mr. Fougere took over.
Been like this for
Maybe
a long
environmental
time.
gardens might be the change.
That's what they did.
Yeah.
It may
They
not have had the
changed it over from more of a
hardscaping,
greenhouse.
if you're looking at a
Meeting in
pie as
August.
much.
Did,
but it
did
doesn't
that
have-
happen when,
I didn't see it printed.
when it was in limbo as a definition? Or
Yes.
did it happen when we had a definition that it wasn't permitted there?
Well, so environmental bought it in 86, is that right?
Okay,
84.
and that was under the 77
Yeah.
bylaws. And under the 77 bylaws, that type of business came under the heading of warehouse and whatever.
Yeah, this is Anthony's.
Well, it was allowed by the building
This is
inspector.
2017.
Yeah,
But environmental gardens
environment,
did.
I worked at a
hardscape.
nursery in town when I was in high school and college, and they bought plants and bark mulch and stored it there and all that kind of stuff. It was always used as that type of yard, and they sold plants out in front of the building. They did sell
We're
plants.
using the
yes.
retail at that time.
They were, yeah.
Yeah.
In Anthony Gardens, he was,
This is all foyer. Foyers.
it was just some exhibits that were given to us
Yeah.
that, it's kind of evidence if you want to look at it that
I
way.
know, I
Yeah.
appreciate it.
What, you worked at Anthony or an environmental?
You're talking about impact.
Waddens Garden Center, which is now Mahoney's, yeah.
One has to, a lot has been said about
Yeah, like this is
the vision from the street view. You really need to, and I hope you have taken the opportunity to do a site visit and understand that a number of us
I believe all of us
abutters,
have walked the property,
Yeah.
yes.
a number of us abutters are dealing from the rear view of the property and the impact that we see and hear. That's very different from the street view, which has been touted in a number of the other submissions. Now, one of the things I also hear is talking about a building commissioner who approved a use.
More than one, but yes.
More than one, yes. I look at that in two ways. One, they approve a use before the use actually commences. They say, I'm going to be a landscaper. What does that infer? There's very little follow-up that says, you've morphed your business beyond what I approved. So I think it's reasonable to also expect that town employees, and I think there's case law that deals with this, sometimes make mistakes. We have to understand that, and sometimes we have to come back and say, that may not have been, should have been approved. Should have been denied. Or that when it started as a landscaper, that seemed to make sense, but it morphed into something that was really non-compliant. So I think we have to be very careful on what we look at as far as approval.
Thank you.
Just Philip Iliopoulos on behalf of the applicant. Just couple of quick points. I think Nancy brought up a good point about Mahoney's and Western Nursery. Western Nursery's been there, I don't know what it was before that, as long as I've been around. And I think maybe Mahoney's too. It's hard to remember them not being there.
What was it before that?
Lawton's Garden Center, that's where I worked before
They
they
both
were
do
bought.
hardscaping. They offer hardscaping. So you have
Correct.
nurseries that grow plants that do hardscaping. They're doing the same thing that Luke's doing, and they're doing it under a pre-existing non-conforming use. You couldn't open up Western Nursery in that neighborhood brand new today. So, that's one thing to point out. And I think, so it's not lost on the board, town council's given you their opinion, which I actually agree with, so I appreciate that, that 2012 is sort of the operating date as to when a landscaper who wanted to do some hardscaping would no longer be able to start that business. And we know this business, this hardscaping, this landscaping, has gone on at least until '84 and earlier, 40 years. And, I think it should also not be lost on the board that Luke did the most prudent thing. Before he bought the building, he came to town hall and talked to the building inspector and said, hey, I know it's been operating as this business. I just want to make sure, because they had shut down for a little bit, am I still going to be able to buy this property and operate under this use? And the building inspector issued a letter, said yes, and he went forward, took out a mortgage, and bought the property. And town council's given you a roadmap and the legal foundation and the legal footing to say that his use, in essence, and, there's 3 tests, but in essence, you have the ability to say, you know what? His use was allowed prior to 2012, and therefore, we don't even have to get to a special permit. It was allowed back then. We had 40 years where building inspectors were saying it was an allowed use. In 2012, the bylaw gets very specific and now brings in landscaping into contractor's yard. And it's a pre-existing, non-conforming use, and it hasn't changed dramatically or at all since 2012. I think that's pretty clear. You've got affidavits from prior owners and operators that have no skin in the game that tell you in detail what they were doing in the 90s, et cetera. So I think it's pretty clear that it has not changed. It's been there for at least 40 plus years, and you've got the ability, I think, to do, if we're talking about doing what's right, you've got the legal authority to say, hey, the building inspector looked at it, it's fine. 2012 is the operating date per town council that researched that issue for us. And you don't even have to get into the special permit criteria. You just operate under that basis. And like I said, I think Luke's done everything right. He certainly has not done anything wrong since he bought this property in 2018. There were some complaints to the town. The town never came to Luke to say, hey, we've got these issues. So he's heard these complaints. He's done some improvements on the site that I think he showed you when you did your walkthrough. He's offering, I don't even think he has to do if it's a pre-existing use, by right at this point, but he's offering conditions to try to satisfy the neighbors, to try to be a good neighbor. He doesn't have to do that legally, but he's willing to do it. And so I think we want to, you know, kind of proceed to see what we can do to help, you know, kind of make right what he stepped into in 18 after relying on the town's opinion. And now we have town council's opinion to back it. Thank you.
Any further questions, comments, concerns? Last one, Nancy.
Question for council. We've all pretty well accepted that what Luke is doing there today is an outdoor contractor yard by today's definition, right? Okay. In our bylaws, in the areas that outdoor contractor yards are permitted, they are permitted only by special permit of the planning board. If an outdoor contractor yard is sanctioned under this finding to be implemented in an area where it is not permitted, does it require a special permit, and by whom?
So the only special permit that would be required is if the board finds that there's been an extension of the pre-existing non-conforming use.
A failure of the powers test.
A failure, right, so if the, or I guess
Failure of item 3 in the powers test.
if you, right,
Two.
or any of them.
So if it's a
So-
change or expansion?
So if it's an extension of the, or alteration of the pre-existing non-conforming use, then a special permit is required to alter that pre-existing non-conforming use. You wouldn't require a separate special permit under a bylaw provision that you're,
For the,
used a
for the
colloquial
site
term,
plan and
grandfathered
the,
from.
and the layout of it and the utilization?
Right, although, you know, those sorts of things could be considered as part of the special permit that the board granted. So,
Okay.
I'd like to
Those
make a
things could be
motion to close the
considered.
public hearing.
I think rather rapidly, if you would.
Second.
Second by Jamie, all in favor?
All right.
Aye. So the hearing's closed. We're going to take up specifically the powers test and
Wait,
hopefully render some decision.
so did he just say those things could be added to the special permit, as in we could essentially approve it, but say it still had to pass a planning board?
No.
I'm not sure how that would work. I think that we
what's the
could-
question?
She was wondering if this would go to planning board if we required a special permit.
You said, you mentioned that it,
can
in
we
the
cross
special
that
permit,
bridge
we
when
could
we-
require that, the planning board requirements also. be
I'm sorry,
met.
no, I meant
Is that what
that
you were-
in considering a special permit, this board could consider some of those things, like the layout of the site and
Okay.
whatnot.
We could stipulate the layout,
put
location,
contingencies on it.
design, size, things that the planning board would stipulate, we could,
Yep.
in our authority, by issuing the special permit.
Yeah, you couldn't, it would not be appropriate for this board to grant a special permit and say, but we're gonna make you first go and get a special permit from the
Yeah,
planning board.
okay, yeah. Thank you.
Sure.
Let's look at the
Let's go through the power steps.
powers
So soon?
test, yeah.
So soon. Get right to it.
We can.
Expressly.
I'm looking at who's going to vote. We have myself, Charlie, Stephen, Nancy, and Erin would be the 5 voting members. Jackie has watched both Mullen.
Excuse you?
Jackie, I did it again. Jamie,
That's a long time ago.
4 years. 5 years, folks.
he looks just like Jackie.
Almost 5 years, folks. Have I not? I
Jamie
mean,
has, she's watched 2 Mullen reviews, but with 2, you're not qualified to vote. You can participate in the decision, but not vote.
Can Jackie vote?
Jackie might be able to vote.
Jackie has not.
First time I've missed two meetings in a row.
ever gets who you
All
are.
right, so those will be the voting members. And we should look at the powers guidelines.
In relation to 2012. That's
Well,
all.
that's the
That is
first
my belief,
determination.
yes. I mean, we can discuss that as well, but I think that
No.
as of 2012, landscaping was included, which tells me that it wasn't before. And I do.
And we have something in writing verifying that Anthony's was authorized prior to. I know we have the
We-
denial from the other place
Well-
permitting the extension.
Right, we have a building inspector's letter from 1994.
The 84 denial, I saw that one, I just,
Well, the letter's denied, but that didn't, everyone gets denied to come to the Board of Appeals.
okay.
So you would get a denial letter.
Yeah, you get a
Go on.
denial letter.
So this says environmental gardens without a special permit, again suggesting the use of the prior non-conforming use. And that's 1994.
94, you may be used as a landscaping business. Okay.
1994, that was
That's what I was
determined.
looking
So
for.
would that indicate that in 1994, he was saying it's pre-existing non-conforming?
Yes.
It could well have been. I mean, it doesn't say it, but
So if so then that
He's
would make it
allowing it.
1994,
It
not
just says it
2012
cannot
for baseline.
increase the number or types of trucks or other equipment and suppliers as the previous occupant.
but it doesn't define them, which is difficult.
Yeah.
But we
The
do have an
landscaping does.
inventory from Environmental Gardens that was pretty substantial and well exceeded what Mr. Fougere is using.
I would say, well, when you get to your powers test,
Okay. So number one of the powers test, whether the present use reflects the nature and use prevailing when the zoning bylaw took effect.
Well, I thought number one was when it became pre-existing non-conforming per council.
Yeah, so when it says when the zoning bylaw took effect, it's the zoning bylaw provision that rendered the use non-conforming.
In
And
this
that's-
case, I believe we agree it's 2012.
Yeah, we did.
With the addition of landscaping to the article, where it wasn't specifically in there
Are we
until
all in agreement that it's
2012.
2012?
They added landscaping to contractors' yards and builders' yards.
What are the alternatives besides 2012?
So just remember that in 1977, the bylaw no longer allowed nurseries in the residential zone. So I think what's a little confusing about this is you had
So they became non-conforming.
the nursery component, and you see those building inspector decisions over the years saying you're pre-existing non-conforming prior to 2012. I think the question becomes, is it in 2012 when a quote-unquote nursery, so the pre-existing non-conforming is a nursery, is it in 2012 that that pre-existing nursery use could no longer be said to include the landscaping component?
Or is it in 94 when the building inspector basically indicated that it was already pre-existing non-conforming?
or is
I mean, I
it
through
think
the-
as of
through his
94, that,
letter
to me,
allowing?
solidifies his rights.
Yeah, so
Well,
I feel like the
77,
building
that
inspector
nursery
indicated it
was
was
not
pre-existing
allowed in
non-conforming,
77?
but.
Right, the 77 bylaw does not list nursery as an allowed use in the,
as a prohibited use, is it listed? It's not,
No,
it doesn't say
it's-
either or, right?
Which
But
is
in
why the
That
building
term comes
inspector
out of the
issued a
bylaw.
letter for environmental gardens in 94 saying basically, you're non-conforming, but I'm
gonna
going
give you
to
the pass.
allow
You're
it.
pre-existing.
So, but, I mean, that doesn't I guess from a zoning perspective, it's not technically becoming pre-existing non-conforming, but that's the building inspector essentially saying.
When
you're
was nursery
pre-existing
added?
By right, can
non-conforming.
run this business as it is.
Yeah.
But
When was
he's
nursery added?
indicating that it's now pre-existing non-conforming, right? So it was
Do we know when
94 the
nursery was
date?
added?
Like,
Well,
I
then
don't,
it
you know.
changed, because that's when the
When was nursery
2012
added?
bylaw came
It's
into
been a nursery
effect.
since 1955.
In the bylaw, when was it added, nursery added, that it could no longer be?
77.
So it became non-conforming in 77.
No,
And
when
then it
was
was
it
a
added to the
pre-existing
bylaw?
non-conforming use, but then that bylaw
1977.
changed in
It was?
2012
Yeah.
to add
You
to
said
the
it wasn't-
contractor
It was taken out in
hardscaping
77.
aspect, and that's why
it
we were
was
using
in
2012.
as an allowed use in 55.
So it was it was removed as an allowed use in 77. Okay, so it
So the
became
letter from the
non-conforming
building
in
inspector in
77.
'94 wouldn't be a good
77 is
indicator as
non-conforming.
it being.
It's always had some version
pre-existing
of a nursery.
non-conforming.
It's had some version of a
I think
nursery.
it's some evidence that it was considered pre-existing non-conforming.
In
Since
1994,
77.
the building inspector considered it pre-existing
Right.
non-conforming in
That's why I asked the
'94.
question about the building inspector and
Right.
whether or not that's a legal aspect to
Yeah.
look at.
So is it when the building inspector basically said, you're pre-existing non-conforming in 1994, or is it when the actual zoning law changed in 2012, is kind of the question that I have.
I think there are two different things. One, as a nursery, it was pre-existing non-conforming since 77.
Well, it was
And then in
non-conforming.
2012, the landscaping also became non-conforming. So there are two separate times when they,
But once you're non-conforming, you're non-conforming.
Well, so
Doesn't
I
matter
think it
what
became
time.
non-conforming in '77.
right,
My question is, when did it become pre-existing non-conforming? When did somebody recognize that it was non-conforming?
As soon
And
as the bylaw changed.
Well, but the building inspector indicated that it was pre-existing non-conforming in 1994 through an approval letter.
post-
For the
77.
nursery.
but maybe in his opinion, in 77, this became pre-existing
Non-conforming.
non-conforming, but there were no complaints or changes. It just
So
went
there was no
along.
need for him to write anything, but the
But he
bylaw
did.
changed.
In '94, he did
Yeah,
write
but in 94
an
he did.
But,
approval.
yeah, but
He
in
rendered an
77.
opinion in 94.
Yeah, but in
is
77.
all-
That said it's
operating as a-
pre-existing non-conforming.
Right. But it also in 2012, if you could do such a thing, became additionally non-conforming.
Yes, but we're trying to find the initial point where it became pre-existing non-conforming, right? So if it was in 1994,
I'd have
2012
to
is.
guess it was
is-
77, that, with
irrelevant.
what we have to date, to understand it, I think 77 would have
Yeah.
been when it became
Non-conforming.
pre-existing non-conforming.
Let me throw out one other thing. So in 77, nursery was not
Close that
allowed.
thing up.
Sorry. In 77, nursery was not allowed, but farm was, including a farm under 5 acres. There were two separate
okay.
line items in the use tables. So farm in 77 was defined as, it's a little inconsistent because it says any parcel of land containing at least 5 acres, but they have a line item for farm under 5 acres, and it says P for
Allowed.
permitted in every zone. So any parcel of land which is used for gain in the raising of agricultural products, and then it goes on to list other things. It includes necessary farm structures within the prescribed limits and the storage of equipment used. So I guess I should temper what I said about, it could be that they took out nurseries and included farms under 5 acres on the assumption that
It was an agricultural
it was
exemption.
a quote-unquote farm use.
Agricultural exemption, under 5 acres.
Now, farms under 5 acres are not allowed under your,
And when did that change?
well, farms or non-exempt farms are allowed in certain places, but I don't think they're allowed in every zone.
So I guess you go back, then I guess you're back to the 94.
The 94, thing is,
Yeah.
the town's legal opinion from the building inspector.
Right.
So Brian, I thought we were just going from 2012, but we're not.
Yeah, I'm trying to steer them just towards the bylaws.
Figure out. We need to
I'm
figure
of the
out-
opinion our concerns run from 2012 to current.
That's what I'm thinking.
I think that's what really matters. Everything else is important to get there.
But
Yeah,
once
but-
conforming, it's
yeah.
non-conforming, doesn't matter.
Once it's pre-exist, well, once
It
it's
does
non-conforming,
matter.
it's non-conforming.
Right.
But then once somebody acknowledges that, and it becomes pre-existing non-conforming in my mind, right? Which I feel like the building inspector did in 1994 when he
He
said.
sort of said
You're
that this is.
non-conforming, but I'm gonna.
So
he
it was,
said this
it was
is
identified in
pre-existing
94 as a landscaping non-conforming company, so that should be the point, that's the hard record we have.
But then it
94,
changed in 2012.
landscaping,
And well, and then it changed again in 2012, but we're looking for the initial date when it
here
became
it is, in
pre-existing.
writing,
More
94.
restrictive in 2012.
Yes, but that's after.
We're of the
like-
opinion, if I'm speaking for all of us, that everything was the same from 94 to 2012, or 94 to current, in the amount of use. We
I don't
can all
think it
agree with
matters. I
Environmental
think-
Gardens affidavit and their evidence that they were running a pretty big operation there the entire time.
You
Are you,
don't.
well, are you moving ahead on the powers test now, based on 19?
No, I'm just trying to clarify for you. I think we're still on one.
I just need to understand what we agree on is the year that it
84.
became
Do
pre-existing
you guys,
non-conforming.
what do you think of 94?
Are you
So
thinking
I don't think
2012?
you want to pick 94 as the date. 94 is a date is one of the dates when it was recognized to be pre-existing non-conforming.
Yeah.
Recognized.
But it's not the
Non-big
date that it
use.
would have become non-conforming.
Okay, so it would be when the zoning changed in 2012. Like, the building inspector's letter in 94 isn't really sufficient enough to make it pre-existing non-conforming. That is my
I would
question.
answer this for you if I could, but unfortunately, that's why they pay you guys the big bucks.
Okay.
But
Right.
Boy, I missed that paycheck.
let me say this. I think you should determine whether or not, when the bylaw changed in 77, the nursery became non-conforming, or was it still conforming at that point under the term farm? Because then you would need to take it forward to when it became non-conforming,
2012.
which might be 2012. I don't have anything between 2012
think
and
you can end up on
77 that
both
would
sides of
suggest
the
that
fence all
farm
day.
is
But
under 5
2012
acres.
sounds like a solid argument either way, for either of those arguments. right?
So,
I
boy, we're
could
gonna have to
easily
make a
fall under
decision, so
farm.
I
When did the
pick
farm, when did the
2012.
under 5 acre farm exemption, was that removed from?
Not an exemption allowed use.
Or,
I don't have that in front of me it's not in the 92 bylaw,
so,
About a farm anyway.
or I'm sorry, 92,
2012,
2012 bylaw.
okay. What was
Um,
previous, what was our one
so-
previous? Because I think that,
If we go to 2012 and say we're gonna decide from 2012 to current,
I'm just saying, if we're determining.
it's at least
that
manageable.
We're saying it's conforming under the the agricultural exemption in 1977. It would be prudent to know when that exemption was removed from the bylaw, because then that exemption would then determine it to be non-conforming. If we're, as a nursery, I
But it
think.
almost doesn't matter when, if you call 2012 the end date. Somewhere between those two dates, it changed.
Yeah.
Why do you know what that date is? It doesn't, once it changes permanently until it's changed again.
But the change point is our comparison point, right?
But-
Isn't that what
So
we're?
Not
that's what we need
changed,
to
it's
determine. Yeah, we need
Nursery,
to
I mean,
determine the
non-conforming is non-conforming. It never
But
changes,
if it
it's
falls
always
under
is
farm,
non-conforming.
It's conforming, right?
Huh?
If it's under farm, then it's conforming.
Right, and
It
then
doesn't
when did it
matter.
become, that's what I'm saying, if the exemption was removed in
It'd be
88,
2012 then, right?
then it became a non-conforming property.
In 88, and that would be our powers test date for
Regardless
comparison.
of what, it became a non-conforming property. You know what I mean? Because we don't distinguish why it's non-conforming when we do our special permits, right? We just say it's either conforming or non-conforming. So if it becomes non-conforming because the farm exemption was removed under nursery, it'd be
I
non-conforming.
think I understand the thread, but what I think is in 2012, we know it was non-conforming. So why don't we pick that point?
Okay, I'm just
Does that make sense
throwing
to
an
you?
exemption. If we're making it,
Well, we have to
conforming because the
compare.
exemption
We're
and
certain
then,
it became non-conforming with the change in 2012, adding landscaping to,
Yes, but if it was
Contracting.
non-conforming
before. then.
15 years before that, then we need to know what happened at that point, because that's our comparison point for if it has become significantly more detrimental to the or not the,
Yeah.
the neighborhood and all of
Can't
those
move
other.
forward in the powers test without establishing that one.
Yeah, we have to know
year.
our comparison point.
Yeah.
Because if we're going back to 1950, we know nothing about what was happening then, so what do we compare to?
Well, what do you know?
How does that
Like, when you
happen?
start a date, 1988, do you know what was going on there? I mean, I was around the town, but I
Well,
can't tell you exactly what was going on.
but
You know
we
what I
have-
I
mean?
think
Like,
there's a big difference between, to your point, there's a big difference between 1955 and 2012 when we're looking at, has the use been altered or extended since? Do you know what I mean? Like, these are the questions we have to answer.
Because to me, we have
Comparison
data
date,
from
the
people
initial
who were
date.
there in 1984 and
Right.
2012 saying this is what we were doing.
Right.
For going back to 1952, we don't have anyone saying, yes, I had a business then and we had 14 trucks and a mule. It's just, I don't know what to compare that to. So if we have a point that we have data to associate, this person had 6 trucks, 2 front-end loaders, and 19 employees, and use that as
60
the.
tons of gravel.
Use that as the comparison point to what is the Fougere Landscaping doing now, then that's what I'm looking for to say, have we gone way past whatever the last conforming or allowed use was.
I just don't know how to determine that. I don't think, we have environmentals has a very good inventory of what they
Yeah,
had
it
on
was a,
site.
Yeah.
it was in 2017.
If it's 2012, I think I have a good data point. If it's even 1984, I think I have a reasonable data point. If it's before that, then I'm like, what was happening at the site at that point?
Here's, I would like to,
I think sometimes you have to do the rightest thing you can.
there's two pictures. One is their property now, and one is the property when they bought it. So that was Anthony's business. So you can kind of see visually the difference.
But what, this is,
2018,
okay.
when they bought it.
Yeah, but we're not comparing anything to 2018. The latest we're gonna go is 2012, right?
I believe so.
Today, so
right.
Yeah.
2018 is helpful.
But
There's
you
no
could,
item.
2018, if you could see, if you notice a significant or increase in activity between 2018 and today, obviously it's a significant increase from 2012.
Well, not necessarily. Somebody could say it went downhill in 2014 during a recession and came
Oh.
back up in 28, you know.
Yeah.
Well, and it's not just, it's the use, right?
Well, look at, I mean, I guess looking at the clearance of land and shrubbery and those type of things.
We still need to pick a date.
You do, you do.
I wish I
So
would've
it sounds like everybody's putting 2012 as our baseline.
Yes.
Circling that.
You guys should
First
figure that out between
issue.
who's voting.
Trees.
My opinion really doesn't, you know,
And do you
But
think
you're
the
still
others
allowed
are
to
on the same
participate.
page?
Right here. That's where this is.
a date would be a good thing for you
Sure,
guys.
it is. I'm,
Go on back here. 'Cause here's the,
with no better information, I think we have to do the best that we can with the information we have. And to me, 2012 looks a lot like 1984, like that stretch. I haven't seen data that says, you know, like there's been a
yeah, yeah.
grand increase between whatever they were doing in the late 80s to,
And now,
Yeah.
I don't disagree.
Here's the exhibit one.
I
in
think
the
it's pretty
file.
similar
Just another time and day, time and period.
generally.
so Paul seemed to be gravitating towards
2018, right before they
2012 as a
2018.
reasonable
Yeah.
anchor point for comparison.
I'm of that opinion. I think that's our guaranteed non-conforming date. If things are before that, well,
Here's some other ones.
You look like you have something to say.
If we don't know, then deferring to town council's opinion is a great response.
all right, well,
Who gave us these
could we
pictures?
consider 2012 the date?
Which
Is that
ones?
something we
I
want to?
am fine to
I'm
do
comfortable
that.
with that.
Yes.
I don't know if you actually need a
Okay.
motion. 2012 it is.
One thing settled tonight.
Yeah.
Great.
Question
All
one,
right,
yeah.
now
9
question
more
one.
to go.
At least it's not a football. Okay, so determination 1, 2012 to current, whether the present use reflects the nature and use prevailing when the zoning law took effect. You find it
Based-
drastically different.
Based on
So
the,
has the use altered or extended since, was what council advised, right?
Is that increase, is that the increase in intensity?
we're looking at number 1,
Whether
correct?
the present use reflects the nature and use prevailing when the zoning law took effect.
That's what I'm considering number 1, too.
Yeah.
I know there's a couple copies floating around, but that's what I have as number 1. Yeah, I'm
And-
using Paul's.
For me, based on the images that were presented in that, one of those exhibits, I would say that they are similar.
I'm of that opinion, if not less. I think it was Environmental Gardens really had it going on back in the day. There was a lot of work there.
Those exhibits that, I didn't see Environmental Gardens.
I think they were Environmental Gardens.
Yeah.
That was all Environmental.
It's all in this one. This was the, it's in there.
Through it again.
If you go, yeah, if you look in there, open it up, Charlie, towards the middle and back, there's pictures of what they were doing, the trucks and stuff. I think it's, yeah.
Is it in one of these online links by any chance?
No, maybe before that, or after.
See,
There's a whole bunch of
I think
pictures.
I have this too.
I can pull that
There are some
It said
aerial
Anthony's.
photographs here that were previously submitted.
Yeah,
um,
I think
But
they are.
Ms. Brown just handed them to me, and if the board wants to see them. It's not new evidence, so
Yeah,
Can
sure.
you
Oh,
Swing it around.
You keep going.
Keep going.
Have that in this
What's the date on that?
That's
On those?
Anthony's.
What's the circa, like 80s, 90s?
yeah.
Oh, it is.
That was
didn't get that packet.
2017. Anthony had
Peter had passed it all
firewood.
down.
Those are pretty
We
accurate.
need to go back to at least 12, right? So
Anthony's, and this is what they're doing right now for you.
We have the
Anthony's,
letters.
Boy, this is what they're doing right
I
now.
don't really find value in these pictures.
Yeah,
I
the
don't, I
two-
don't
it's a
see.
close shot.
Yeah, I
You can't see
really
much.
think that those are
Yeah, right.
wonderful
It's
depictions.
one
of
item
environment.
until,
Since
it's
1978.
Anthony's, but it's a close,
This is from their
Really see
website,
much.
so they've been doing that.
Those seem quite a bit more than that.
huh?
And an inventory, is the inventory sheet
Yeah,
on
the
this?
inventory
Doing
sheet's on
in
the
78.
previous page there.
that's what they've been in business since
This is just
78.
Anthony's. Logging trees.
An
They'll do
affidavit
one
or
thing,
something.
logging
They
trees.
wrote a letter with their inventory.
With the,
It's in there, Brian. It's either on the
I
next
just-
I
page,
have it.
I just
maybe.
think this,
there's an inventory of
So we have an
equipment.
inventory that came to us through an email
because this is Anthony's.
from Anthony's,
This is Anthony's
that I have on
inventory.
the screen right now.
But this is Anthony's, the way Anthony has it. It just looks so,
But that's their
This is
equipment. I mean,
Anthony's.
it's huge.
But
It's
it's-
an enormous amount of equipment.
This is 2000.
they're saying they stored all that on site.
You're supposed to take a picture
can't.
from 2004 and
they
make
had
one
one
of
of
one
those.
like this is 2004 too. Like this isn't 2012.
We don't have the
I
right
don't know.
years.
I don't
Right.
really like any
So-
of those.
It's not necessarily helpful.
What's not helpful, the Anthony stuff? Is that what you're saying? Or?
The aerial photographs were from
Do you want
2004.
to see? Do you want to see?
You can
them?
look at them if you like.
2004 though, so I don't know what's.
The ones I just sent around are, I think, 4, 11, 12, 14, and 29.
Thank you.
So you have it for comparison. Pam, excuse me, do you remember which packet those photos were in?
I think so.
Just so I can pull it out up electronically. September 12th?
I didn't get that packet.
You had to be here.
Huh?
You had to be here.
I can't, she said she handed me that.
I'm just teasing.
Oh, that's Jackie, not you.
Oh, you sent it to Jackie? That's what it was. I spent hours.
This is what they are agreeing to do now. No more than 8 non-residential dwellings.
We talked about it.
And this list is enormous in comparison.
But seeing this is what it was before they bought it. This is what Anthony's had.
I don't think those pictures. I don't think the pictures are wonderful.
But he would have taken everything out.
I know, I'm just saying, but
He didn't sell the equipment.
it doesn't look, and how much he cleared out. Look how, he's all the way up on
It's
the
his
property line. I'm just saying, presence,
I'm not
right?
following that.
Some of the trees were dead.
Looking at the intensity,
That's 12 and that's 21.
yeah.
I mean, you still got the
There we
structure,
go.
you still got lots of stuff around. I mean,
204.
there is more stuff here, but is it,
Increased?
yeah, but
Yeah.
what,
Right, how do you define
Well,
that?
aren't we still on one, which is the
It's-
nature and use?
Hey, do we have to check off number 1 first?
Yeah.
I'm of the opinion we
Circling
can. I
back.
don't know if we need to vote
I
on that
also
or just
am in
agree.
agreement that we can check off number 1.
Yeah,
In agreement
I think
that,
it's the same
Item
nature
1 has
and
been
use.
met?
Yes.
I don't think we need to. Item 1, do you have
yep,
consent?
I'm good with that, I'm number 1.
Okay.
Item 1 has met the powers test.
Did you?
Item
you agree
2.
with
What
that?
about-
You're voting.
Yeah, I agree.
I'm real confident.
Reluctantly,
This is tough.
Stubborn
Like, this is
people
not
in
the
it.
greenhouse that it was in
We got that. So
1955.
number 2.
it's-
Item 2.
It's a
You don't think it's the
huge-
same
Whether there is
nature
a
and use?
difference in
I
the
don't, but it's
quality
like
or
the
character,
legal
as well as the degree
frame,
of the present use.
You know what I mean? I agree. Compared to 2012, yeah, I agree.
Any
It's the same.
opinions?
What?
Item 2, whether there is a difference in the quality or character, as well as the degree of the present use.
Might be where your concern is. All right.
Well, from 2012, no. When comparing with, I mean, if we're comparing to 1955, I'd have problems. You know what I mean? But for 2012, no.
Okay, well, that's what we're doing.
I don't see,
I'm good, I'm not voting, so.
Yeah, well, there's an opinion.
No,
We're
yeah.
in discussion.
Oh, okay, yeah. I
Charlie?
agree with it, so yes.
Item 2,
I could say yes for number 2, but the pictures even.
I think there's a difference in the quality
Nancy's
or
good.
character,
I think it's met.
as well as the degree of present use.
it's really very,
It's obviously not identical, but it's close to being.
Combination?
Totality
things
of
change. That's not
everything.
really the question. Is it turned into, did it go from a Cumberland Farms to a Walmart? Did it go from a Walmart
Well,
to a
you have to use the landscape
change? I
contractor
mean-
yard, right? If we're determining that use, right? The use,
I
is it
think
a
it's-
contractor, landscape contractor yard defined from 2012,
Right.
right?
Right.
So that's what I think the decision has to be made on, right?
2012,
Yep.
from
Right.
2012.
So we agreed.
Right, so that would be,
Jamie? Yeah.
Two's met. What? I'm not voting.
Number 2.
You still have an opinion.
You have an opinion.
We're not voting yet,
Not
we're
voting,
asking for
but,
opinions.
we are not voting. We're trying to qualify the powers test.
We're deliberating.
I think the intensity, I mean, looking at the I mean, this aerial's a little hard, but looking at this aerial from 2018 and what he has done definitely would bring into question
But again, that's
the
18.
intensity from when he purchased the property. I know it's not 2012,
Yeah, but
but
If you consider everything too, I mean, you can consider that. You
Yeah,
can consider
consider- I mean-
all the images from environmental, considering all the images from Anthony's, all the affidavits.
so I find it hard to look at these pictures from Anthony's because it's one up-close image. Like, I
Yeah.
can't see, I see a log, they're
You have an
logging.
opinion?
It's like one piece of equipment.
Yeah,
Yeah, there's
there-
no way to tell
There's
what,
no,
like.
I
I think you can rely
unfortunately
more on the
can't.
affidavit.
But there's also an
I find
email or
affidavit.
letter that
Yep, I
the
see-
owner wrote that said,
Right.
this is what we were doing.
Yeah, this is the equipment.
Yes.
That's a huge
clear
list of
to tell.
equipment.
the activities are.
But the letter doesn't say, so it says here that,
no,
Right, it is substantial. That's the issue.
right,
it's not
that this is the equipment that he used, but it doesn't really specify he had all of this equipment on the property simultaneously, in my opinion.
When they were taking one of these pictures, yeah.
Right,
Like
do you know
it
what I
kind of-
mean? Like,
Well, the equipment goes to work. That's what
no,
his
no, I
equipment
get it,
does,
but,
that's what
I
everybody's
mean,
equipment does.
he listed a ton of equipment, you're absolutely right, but was all this equipment simultaneously on the property? Or
Was
this
it at
is
jobs, like sitting at jobs?
sitting at
for
jobs
the-
rotated?
Well, that's
what
what
they
he does
do.
as well, right?
I know, no,
All
I'm
his
not,
equipment
look,
is not gonna be
okay.
on site. Maybe in the winter, maybe
I know,
not.
but what you're saying is you look at that list and you picture it all sitting on the lot, but that's not the
Right.
case.
That-
Like
it's
you're
not
not,
the
it's not all
case.
just sitting,
Like-
just because the list looks long doesn't mean it's all sitting on the lot all
Right.
at once, yeah.
That's-
Because to
that's
your
all I'm
point, it's
saying.
out and jobs,
Right,
and yeah.
you're saying it's a lot of equipment, yes, you're right.
The
It is a lot
photos
of
from
equipment.
2018, when Anthony was trying to, or his family or whatever was trying to sell,
Mm-hmm.
if you are winding down your business, you're not necessarily bringing in fresh inventory, so everything could look smaller at the time of the
I'm,
at the
I'm just
photo.
looking at the clearance of vegetation.
Oh, that, he addressed that though, where he
Yeah.
cleared like
I
the
know,
dead
I know,
trees
I know.
and then new
And
stuff.
again, it's just a factor of an evaluation, in my opinion.
Okay.
It's my
I think we have a
opinion.
majority of people agreeing with
In my
the
opinion,
second
you asked for my opinion.
of the
You asked
powers
for it.
test.
With the, that's not, clearing of vegetation though is not
Would be an
the
indication
use,
of
really.
expansion of his use.
Not necessarily.
Not necessarily, but
I mean, it could be.
My
Yeah, but trees were
opinion.
removed when we did the walk because they were dead. He took trees
But
down
is that
because of
still,
vines and
like,
everything, so that's
use?
one thing.
Of the property, I
Kinda
don't know if that's
bittersweet,
really
I think, as I
use.
understand.
could just be, like I said, could be an indication of expansion of his business, because he cleared the area so that he could put more supplies, store more, grow his inventory, grow his storage, grow his hardscape storage, grow, and to intensify his business. That is all I'm saying. I'm not saying that it's a yes or a no, but just looking at these two in
So you're on the
general.
board, you need to, like, decide. I mean, this is why we're here,
I'm not
so.
voting, so you guys knock
All right.
yourselves out.
So it looks like we have
Sorry.
some confusion on two, but
Very
I think we have.
There's a lot to
The
digest
third of
here.
the powers test is whether the current use is different in kind in its effect on the neighborhood. That's pretty critical, but I think that we can get through it, so. Opinions?
I would lean towards, well, depends on who you listen to. Some neighbors say they're vibrating their dinner tables, you know, with the bobcats moving around, and others say, hey, I never hear anything. So,
And it may well be the case, it's just how it's,
yeah. But, you know, based on the mixed response from the various neighbors and the written statements from previous owners, I would have to lean towards, you know, there's no concrete way to go, so based on the numbers, I would lean towards no, that there's not a, whatever, significant different in
well,
kind
the
and
current
effect on
use
the
is
neighborhood.
different in kind, which I don't think that is specifically, in its effect on the neighborhood. So machinery has been there forever, as far as we can determine, through the inventory of environmental gardens, through testimony, through photographs. The equipment has been there. The equipment is, you're gonna hear it, you're gonna see it, and you're gonna feel it at times. So that's, it's not like there's new equipment in there or different equipment. It's bobcats and this.
And they're still keeping the front of it, the front appearance is still, well, I mean, no one driving by would know the business or what's
Right.
going on
And-
behind the
And
house.
the argument is
They
some of the concerned
still-
neighbors are not
Yeah.
visually seeing it from the front.
Still
They're seeing it from the back.
same. There's no different, I mean, I drove by that house every day for 3 years, so I saw the sign in the firewood shed, but I would have never known until this came up that was all behind that house, so.
Do you have a comment?
Yeah, it would seem that judging of whether there's more activity or less activity is strictly in the eyes of the beholder. There's no way you can apply a empirical number. The only thing you can apply a hard number to is the amount of equipment that's on a previous list and the amount of equipment that he has now. That's the only thing that will tell you whether or not there's more activity or less activity, period.
And I think
Anything else is
substantially
hearsay.
less equipment is on site now and 10, and we also have the advantage of controlling that more doesn't show up.
Right, so that going forward, you have a benchmark now, going forward, as that list of equipment is the best benchmark of a previous time.
Correct, correct.
In this decision, can you recommend that a building, I know he wants to put a building up, could we, try to help the town in any way to get that, to keep the noise at a, like they were talking about the salt and inside, the trucks inside, the equipment inside, so people don't hear it as much and see it as much that are in the back? I mean, is that something?
Dialogue with the neighbors could be very helpful moving forward, which you do have,
But the
right to
suggestion,
comment.
because he was denied already once, right, for the size of the building, and I mean, I'm just saying, does the board, I've never voted on anything or talked about this before, but could you make a suggestion that was considered by the planning board to help him get that, to kind of lower the noise in the
I honestly think
neighborhood?
that might be an overreach of our authority.
Okay.
I don't know how it would be worded in a motion, perhaps, is.
Well, I guess one thing you want to think about is if you know there's a proposal to add a building now,
Well, the
At some point
uproar
that may
became
come-
of the building. That was
Right.
what the tipping point
Right.
was.
so is that something that would, in your minds, constitute an expansion of the pre-existing non-conforming use? You could, I think, say in this decision, if you find that there has been no alteration of the pre-existing non-conforming use, you could say something along the lines of, and, construction of a barn otherwise in conformance with the zoning bylaw, the board finds would not constitute an alteration requiring a special permit from this board, because if anything, it's going to decrease the effect on the neighborhood, if that's your determination. I don't want to put words in your
Yeah,
mouth.
no, I'm just asking the question of whether that would help the situation, The neighbors in the back are very concerned with the noise, and when we walk back there, you can see other homes back there, so,
Oh, yeah, I mean, it's,
if it was something
as the
that,
gentleman said, what you're seeing from the street and
Right.
is not everything you see, and from their vantage point, it's
Right.
very different.
Right.
So it's something to consider for sure.
And I will, to Mr. Glenn's point, this list is for their entire 9 years of business, so, again, my thing would be I'm sorry. I know.
All right, so are we in agreement that whether the current use is different in kind in its effect on the neighborhood? I do not think it is.
Say no also.
I agree.
Okay.
Peter?
I agree.
Bud? Jamie?
Is it different in kind? I agree.
Okay.
I say it's not different in kind.
A unanimous decision. This is
That's
incredible.
nice.
Okay, so based on the powers test, do we vote on that, on the powers, or can we just go to a motion? We're of the opinion that the powers test is proved to be,
So that's that's the end of your inquiry. If the board finds that there has not been that there is a pre-existing non-conforming use and there has not been an impermissible alteration of it that would require a special permit, then you would take a vote to that effect. Going through the powers test, which you just did, is the subsidiary findings.
we do not need to vote for a special permit.
That's
We
right.
just would
But what you would be
turn
doing,
the decision of the building inspector.
right, you would be making a determination that the current use is a lawful pre-existing non-conforming use and has not been unlawfully expanded.
And how would we word that so that we can
Just
include the
like-
conditions?
Just like
Yeah, so you would,
Very well, you should be a lawyer.
that law degree's coming in handy.
so, it would be the same vote, but just, based upon those 6 conditions, and maybe, I don't know if the board intends to alter the one about business hours to exclude snow.
Well, and we can take up the 6
But
conditions
it would
next.
be based specifically upon those conditions being in place and remaining in place, the board finds that there is a lawful
Based
pre-existing.
upon agreed upon
non-conforming
conditions, which we would list.
Right.
Okay.
Okay. Where's that list?
Sounds like a motion.
Did we
Guess
want
I'm
to
looking at
talk?
the attorney.
I would try it if
Did
we had
we
that
want
list.
to talk about the specific
Oh, the 6 conditions, yes, I think that's a very good
before
idea.
we
Where's that?
vote?
I'll go back to those.
You have it
And I guess one
printed?
thing to throw out is one of those conditions related to screening, and I don't know if you want to get any more specific than that.
Visual buffers to the abutting residential properties shall be maintained by fencing or evergreen vegetation. That's what we have as a condition.
It's
You mean
very
like the height
vague.
and width and depth of the vegetation, I mean?
I think that's what he's thinking, is clarification on that would be wise.
Yeah.
Not to be less than 8 feet. I think that was an 8-foot fence that he had there. Is
Well,
that a
it has a
6
huge
foot,
burn in
6
the
foot
back.
fence?
He can't answer that.
The fences that exist are 6 and there's a 4-foot berm on the back property.
It's only if it's thought it was
Did you
bigger
guys do the berm, or did your
Can't
abutter
ask
do
him
the berm?
questions. You can't ask him. Can't.
The abutter did the berm.
I don't know if they did it, I think.
Oh, okay, I'm sorry.
I wasn't there.
Can't ask him any questions. You can't ask him questions.
Oh, thank you
Oh,
for
yeah,
the correction.
we're close to
Oh.
the public hearing. That's-
Oh,
Yeah,
my apologies.
yeah, well, that's, no, that didn't happen.
Stricken
Strike
from
that
the
from the
record.
record. Jinx.
So,
I honestly, I don't like condition number 6. I just want to strike that altogether.
Which one is
I think it's way too restrictive.
Well, I think we're not going to issue the special permit. We're
So,
going
yeah,
to
there's no
overturn
special permit being.
the decision of
They
the
don't need to
building
have any
inspector. So
conditions
6
at
is just
all?
wiped, right.
Okay.
but do we
So do we need to have any
bring in
conditions
the
at all
other
then?
5 conditions? Like, does
I know,
that?
we don't really have to,
How do we put
right?
conditions on the
If
overturning?
we're not granting a
of the
special
letter?
permit, we don't.
I'm saying we don't have to do any conditions at all. We can just,
Yeah.
Let
at
'em
all,
go as
right?
they've
We can
been
just be,
Yeah, we don't have to put conditions in. They're offering to, I think it's a healthy,
Can we put conditions on the overturning of the building inspector's letter? Because that's all we're doing. We're not actually issuing a special permit to put conditions on.
we are overturning the decision of the building inspector. We can do that with
With the
conditions.
conditions, okay.
Yeah, I mean, I think it's semantic, but
They
what you would
chose not
be,
to follow it.
what you would be doing is saying,
Putting
you're
it in the-
overturning the determination of the building inspector
However,
finding that this is a lawful pre-existing non-conforming use that has not unlawfully been altered based upon your determination of the current use, and that that determination is contingent upon these conditions remaining in effect.
So,
In other words, this is part of what is happening now, you're gonna find, and if that changes, then your finding would change, and they would
Which
need a
would
special permit.
Potentially be another complaint towards the site and the future things going in a way that is acceptable.
so not saying that he would, but if he started work at 5 a.m. every morning, as soon as he got this condition, what would happen?
Well, he'd be in violation of the town bylaw as well. You cannot
Okay.
start work before 7 a.m. anywhere townwide.
Okay, so then all of that, the timing stuff doesn't matter then, because it's
I mean, that's
aligning
way
with the
to-
rules of the town to begin with, so
it's
it's,
noise ordinance
Okay.
too.
Yeah.
so, but if he got like 10 non-resident employees where he agreed to limit to 8, what would happen?
So if the building inspector had a complaint, he would open a new complaint and have,
And the building inspector at that point would say, well, I have the ZBA decision that this is a lawful pre-existing non-conforming use as long as you're limited to 8 employees.
Okay.
But now that you have 10,
You're no longer lawful.
Okay,
that constitutes an
So there'd be
expansion of
some
the
teeth.
non-conforming use.
okay.
that's gone.
Can I ask the owner a question about number 4?
Ask who? No?
What's your question?
The question is, am I correct in when you're looking at the property from the street?
Well, you can't ask him.
Yeah,
You're asking
we
us,
might be able
'cause-
You
to
can ask
answer
us, because
though.
we did a site visit, we can
Yeah.
probably answer.
All right, well,
right?
when
See if he
looking at
nods
the,
his head.
oh, it's all part of the same question. When you're looking at the property from the street, there is a very treed area to the left of the property in the back. Depending on where you put a fence or greenery, would make a difference in terms of how, if you were looking from the abutters standpoint, it would look one way, depending on where you put the fence. In relation to most of the abutters to the back right and to the left, it's all open area. It won't matter where you put the fence, it's gonna look the same.
Well, I think the fence is gonna go on the property line. It would be the
Fence is
Well,
already
my,
there.
practical.
again, my question is this,
Maintain it.
if you put it on the treed side, if you don't put it right on the
Right-hand
property
side.
line, it's
Yeah, he's
gonna
just gonna
look
maintain it.
much more favorable to that
It just
abutter.
says he's gonna maintain the stuff. It's
Do you
already
have an
there.
objection of where the fence
This
goes?
side, I think we're concerning ourselves with.
I don't,
you
I
can't-
think he was pretty amenable to anything, really.
If you put it on the property line, it's gonna look one way to the neighbor, all right? But there's all treed area, which it didn't seem that was being used in any way, and if you put the fence back from the tree line, it's gonna look like the guy has a bigger yard, and it's all trees, and look like greenery, which, if I were living there, I would find more acceptable.
Give or take, this is,
I think one of the things is that we haven't heard any of the abutters say that that would help them in any way, so I think we're,
Well, the abutter, I think that's a record of that is here. And you can ask him.
it's a rather risky proposition to reopen the public hearing.
You
So-
can do it if you want, but.
Yeah, I know we can, but I don't know.
I'll have a couple of votes, no.
Well, you're asking,
well, it is vegetation or fencing.
But it says it's gonna
No.
maintain.
it's where that is placed makes all the difference. It's all trees. If you remember when we were out there.
Yeah, no,
The
I
area to the
do.
left was all trees. Looked like wild,
Yeah.
so forth. The area on the other side was cleared all the way out to the abutters. So if you're gonna put a fence on the left side, if you back it up from the property line, you will see more trees and will be a much more attractive if I was living there, as opposed to putting the fence right on the right on
on
the
the
property
line.
line. It would make a difference.
Well, and to not clear trees, to
Right.
put the fence up against the property line would keep the, more of
But
a
I
buffer,
I think
yeah.
we're, if you look at the first, it's saying right there, they're not going to avoid further growth of the business. What did it say? Not clear anymore? Geographical area of the site used for business will not be increased. So they wouldn't clear out any more trees anyway, so it would
Right,
stay
so, but if
all
you put,
trees.
if you put the fence back, this is all gonna say trees, it's all gonna look wild, and it would look like you live more in a rural area than you do a business area with the fence right on the line.
He doesn't have to put a fence
He's
there.
not gonna put a fence. Why would,
I don't
why would he
know
put
that
a
he
fence there?
anticipates it.
Yeah.
But what we would be asking to do is visual buffers shall be
He's
maintained by
maintaining-
fencing or evergreen vegetation.
Yeah.
So he could leave it alone.
But when we were there, I know he did mention that he wanted to put more, he just didn't have the financial means to do it at this time, but he was going to expand the fence to include that left
I don't know how
corner.
to ask him to put a fence farther on his property when.
No, right.
I wouldn't do it. I wouldn't give up, the land's gone. If you put a fence up 8, 10 feet away, that land's gone.
It's his
Well, he-
property line where he
well-
has to put the fence, I think, right? I mean,
Well, his representation put these on the table.
Hmm.
So he's willing to live with all these. Maybe he's willing to live with that as well, to be more of a friendly neighbor.
yeah.
Yeah, and I think that neighbor is in agreement with the use here. He's
The
he's
only
not
way
one
you're
of the
going to know is if
aggrieved
you ask.
One of the
abutters.
supporting neighbors.
Yeah.
Yeah, his next door, but yeah, the one to the left, I know is right.
The only way you're gonna know is if you ask them.
I have a motion to open the public hearing. No, no one will give me a motion. Could I have a motion to open the public hearing?
Yes.
Yes. Second?
Second.
Ally, all in favor?
Sure.
You should be a
Oh,
judge.
Yeah, you guys have to vote.
Or,
Yeah, but
where were you?
how many people are voting?
Yeah, who's voting, isn't it? You 5 on this?
5,
Is it the board or is it the vote?
it's the board
Well,
for this
it should
case.
be the people voting on this application.
It's
Yeah.
the 5.
You can't yet.
Well, you can't yet, because we're not opening it. All right,
Okay. Show
4
of
to
hands
1.
again, please, just so I can,
all in favor of opening the public hearing?
3, 2.
3-2.
3-2.
I
It's
think
just a
that-
Motion's
majority,
denied.
right?
Oh, this-
It's not a super. So it's open.
So we're
Okay.
fine.
Okay.
Come on up.
So it's open, right?
Is it open?
Yes, so you can
It
answer,
is
you can answer the
He said
question
it
now.
failed.
He said
It's gotta be a supermajority.
No,
To
not to
reopen?
open
You
it.
don't need a
Reopen.
super majority.
No.
Not to reopen.
Oh, we're good. We can open the hearing.
Yeah.
Okay.
Please,
2, reopen.
expound on your plans for the fence.
There's no amount of fencing that's going to make that buffer that's within legal limits, whether it's a 6-foot or 8-foot fence. You're talking about the visualization from our homes in the back of the property. So it's absolutely ineffective.
Vegetation wouldn't offer you.
Hardly, and certainly not anywhere near immediate. If he doesn't have the funds to do it now, he's not going to be able to put mature plantings in there. So I suggest that the attempt, it's an attempt to show how friendly he might be by saying he could do it, but it's not going to be effective. It's not effective now. He's put a spiked berm up. And it's about 20 feet tall. You should have seen that. This is grossly unacceptable.
That's the big burn that I'm thinking of. Yeah, there is a
It's
big
grossly
burn back
unacceptable.
there.
Absolutely.
There is a
Grossly.
taller burn. Somebody mentioned a 4
Yes.
foot, but when we were there, like the back left corner.
That's
I don't
correct.
believe that's his property.
Okay.
It is
yeah.
his property, and it's up against the property line. So it's complete, unless typical, fencing and typical plantings are going to be grossly ineffective to buffer the neighbors and the rear neighbors. Absolutely. This is a sham.
Thank you.
I believe it was reopened so that I could answer.
Well, it's reopened. The public is welcome to comment.
Super.
That's
What
exactly Steve's,
what questions
concern.
can I answer? The fence, I don't mind where fencing goes. I don't mind where trees go. Whatever you'd like.
I guess Mr. Diggs' concern was on the left side where there's quite a bit of vegetation. He felt a fence would be more problematic than just leaving the vegetation as it is.
Well, a fence captures noise, and even though Mr. Thatcher just stated that it
That's okay. We'll just stick to the
wouldn't
point.
do anything, I would be willing to do pretty much anything. I mean, I was gonna put the fence up just to delineate property line, as my other neighbors did with or without my help, or we put it up for them. But I'm not opposed to making people happy. No, I'm fine with that in any way, shape, or form. 8 foot, 10 foot, 4 foot, what doesn't matter.
But if the neighbor who would be on that side is not here to say whether or not that would be a benefit, then.
He is. He just spoke.
I mean, to his
It's up in the
point,
back corner,
to his
right?
But-
point,
But
a
the other
4 or
person,
6 foot fence isn't
You
gonna
like
block anybody's
store
view
them
of the
both
property.
there. Is that the
I
side we're talking? Like,
mean,
I don't.
I think,
some extent
Mr.
the
Diggs is
fence
referring to
is
Mr. Weber's property, maybe now or formerly,
Who is Mr. Weber?
To the
left-hand side.
left as you're
That's what we
facing your
have on
house.
the,
Where the boat is,
Oh, that's
right?
that's Mwale.
To the left as you're facing your house.
Right, that's Mwale.
And that
Charles
individual,
and Catherine Mwale,
and that individual had no issues.
no.
Right.
So-
Their property goes all the way back
Yes, yeah.
to
Fence line goes all the way
Mr.
back.
Thatcher's and.
the fence
You have
line
a-
ends between he and I because
Yeah.
we share garden space.
Right.
Yeah, and you have a wire fence there now, right? Isn't there a wire fence that?
My
somewhere?
property goes straight back. There is no jots. So if you look at the property, it's it's like a obscure rectangle.
Yeah.
But my point is, having Mr. Fougere put up a fence at whatever expense for a neighbor who doesn't care if there's a fence there or not
Yeah.
is an additional financial impact on him for no benefit to either him or that neighbor.
And should we force him to put up a
So-
fence if the neighbor doesn't think that it's an
Right,
effective
like-
barrier anyways?
Right.
you
Like,
know?
it might be great for some neighbors, but the specific one that's there says, I don't care, I'm really happy, this guy's awesome, so putting up a 10-foot fence is not necessarily beneficial.
Hi, Nancy.
Hi. I would like to make a suggestion to you that since you're going forward with this and the use is a special permit in an industrial area because of the impacts to the neighborhood and the environment, that you consider a condition to be added that your applicant incorporate containment and capture systems for potential hazardous materials to be used on the property, including motor oils, salt, and any other materials that are hazardous to the environment.
Is that something that we normally do for this type of business?
No, but we would if we,
The
if it
planning
were
board
coming
would.
through an
They do
industrial
the
area
commercial
for the
stuff.
utilization. So the issue is that a outdoor contractor landscaping yard has a lot of chemicals and a lot of trucks. And the trucks themselves are prone to, drop motor oil and such, and it is considered a hazard to the environment. So we would absolutely require pavement in the areas and drainage systems where those trucks were being used. We have had applications for salt storage systems, and it requires an actual state approved containment system for that salt. And if he's working with fertilizers, you're again going to have hazardous materials that require containment and storage. So, these are all now going into a residential environment here. And I would strongly encourage you to include a condition that those containment systems be incorporated per code and to the satisfaction of the building inspector.
Are those systems applied in the big garden nurseries in town? Like, does Weston Nurseries have to?
They do have, I don't think Weston deals with salt. What they deal with is mulch, which, isn't really a chemical. I mean, they're not doing spreading fertilizers on lawns.
But they
They're-
do deliveries and have lots of vehicles, so what
They
is-
do.
What is their
They do.
capture system for all their oil
I
and
can't
stuff?
speak to that. I don't know.
I know the
I can
yards
tell you
just
that
go
when we have approved landscaping services in industrial areas, these are some of the conditions that we would impose
when you
upon.
mean-
But not on all of them, just on some of them, depending on the nature of their business? You'd look
All
at
of the
them.
ones that I've approved, that have come before me have
Are they all
indeed
New
dealt
business?
with, pardon?
Is it all been new business, though, or is it,
Not necessarily.
okay?
Yeah, not necessarily. In some way, it was either a changeover of the business that changed it from something into outdoor
So a new
landscaping yard.
classification, though.
It was new classifications. In some cases, it was changes to the building or changes to the
New
parking,
construction.
new construction. But we would absolutely be looking at drainage systems, containment systems.
But that's all required by code, too, when you build new construction, new classification, that's all required by code, yes?
That's required to get a building plan review.
Yep.
That's right.
Okay.
So, I mean, just consider
Yep.
what you're doing here is endorsing this business in residential, this use in residential. And there are some very critical requirements around this use that I would recommend that you include in your conditions.
You guys were trying to get a barn, right? A garage, was that for vehicle storage? So you could have proper place for all your vehicles, so they wouldn't be like sitting out and, I don't know, leaking stuff into your soil and such?
My vehicles don't leak, they're all brand new.
Well,
I don't
that-
think that,
There you go.
I don't,
would that make a
I
difference?
pay a lot of money to make sure my vehicles don't leak.
this is true.
Would
That's
that make,
embarrassing.
Nancy, would that make a difference if they're stored?
If they had an
Inside.
appropriate store place that could have appropriate collection system?
I
It
mean,
would, the building
it
have
would
to.
certainly would, you know, if we were looking at it, we'd be looking at what's the floor system in it, what's the drainage system in that floor. In terms of the salt shed storage, we would be looking at how is that contained physically so that you don't have rainwater runoff from that salt getting into the
He
soil.
doesn't have that yet, so right now it would just have to be.
Well, he's
based
saying
on
he's loading a salter.
outside. No, I mean, he doesn't have
Yeah.
the building yet.
Yeah,
So right now, it would
that's
just have to
right.
be based on
Yeah.
him storing stuff outside.
Yeah.
We could could we?
In my opinion, no asphalt is not good for the environment.
I would certainly agree with you.
We can't
but,
pave that whole place. It's worse and worse.
No.
You just, all I'm saying here is that there are issues to consider that should be put into conditions of use for this application of use. That's all.
What if we,
I'd like to make a motion to close the public hearing.
Yeah. I'll second the motion. That's a really, that's a,
the audience seconded
Can we,
it.
can we close the, Brian, can we close the public hearing?
close the
Yeah,
All right, that's that.
and,
All in favor?
Yeah.
all right.
Okay. So as a condition, I think we could put a spill containment requirement.
I don't know if I'm comfortable with that because
They're under guidelines anyways. The
Yeah,
EPA is,
yeah,
we're
that-
overstepping everybody's
yeah, I don't
boundaries.
feel like that's our thing to do because we don't know what these,
yeah, but we're essentially approving that they bypass what would normally go through the planning board. So, I
No.
mean,
It's
I-
already-
We're approving what
we're
they're
approving
doing
the
today and what they've
extension.
done
Yes.
since 2012 technically, but
But if
as
we
we
didn't
know-
approve it, they would have to start over, and they would have to, right? If we were to not approve this,
I don't know.
If we
I mean,
didn't
I
meet
don't
the powers test, we go to the special permit, and then we might be considering stuff like
We're
that.
not
But right
approving
now,
anything
we're
that's
just
not
looking for
happening
extending the
and hasn't been.
I'm
non-conforming
really,
use, and I
I'm
don't think.
very uncomfortable with that.
with what?
I'm very uncomfortable with, I don't know, with the thought that they're gonna operate a business outside of the bounds of what the planning board would ensure that they do.
But we're
Operate a
just
business as a new business.
extending the lawful non-conforming use. And
By
then
right.
we're saying per town council's guidance is that this is the current use in effect and it shouldn't exceed this. When you're adding in all these additional parameters of containment, you're adding conditions, not what's currently in use.
But we're
So I
already,
think
that's what we're doing,
where
we're
at the
going through
special
all the
permit.
conditions we're gonna add.
But those,
right?
no,
Those are
we're
conditions,
we're
they're
not adding
voluntary.
conditions.
They
We're saying
offered
they
those.
have 8 or less employees, fine, you can't exceed 8 employees, so that's the current use right now.
Yep.
You can't exceed that. Are you getting,
Yeah.
I mean, it's a
We're
by
not
right
approving
use.
anything new.
Our conditions are that they maintain the current.
exactly,
and
it's not,
extend it, and
And
that
that
would be
includes the
additional
standards issued
conditions
by the
placed
EPA
on
for
it.
every
So,
property.
so right now, they don't have a salt containment system, so we would be adding new,
Yeah, no, I understand,
Which
yeah,
I don't think
as
is
opposed to,
proper.
yeah, to
you
Nancy's
have to
point,
park
having
your
made
trucks
sure
on
that
tarp
the
just in
current
case they
ones.
leak one day. I mean, that's,
So are you indicating that the EPA would monitor that already? Outside
By
of
law
this
now, yeah,
process?
they monitor your property. If you have a spill on your property, they're gonna wanna be involved with it.
Like if you
I mean, by
start
law,
changing
you're
your
supposed
oil
to
in your
report
backyard
any
and throwing it in the,
If you have if you have a spill. But
And then if someone
Yeah.
goes to buy it, they're gonna
They
test the
are a
soil.
registered business. So the government powers to be go over and randomly inspect people. If he orders or buys hazardous materials or tons of salt, tonnages of salt, people do random inspections and checks to make sure. And if he's not properly prepared or when he gets inspected, then that's on him and his license. But we can't go
He would
around
be
and
in violation
monitor.
of the law if he
Yeah,
was to.
we can't go around and
not
monitor
take care of
everybody in
business.
all our houses in our neighborhood. I mean, that's well beyond our scope
Yeah,
and
I
ability.
think it's a good idea that he not become an environmental hazard, but I don't think it is our purview to say, we're gonna put environmental restrictions on you
I
because
would
we
definitely
don't have
encourage to
that.
make sure you're following those regulations if you're hauling salt and such, but.
I think that we should stick with the 6 that were given, and I'd like to see, 5, I'm sorry, yes. I'd like to see
Well, Glenn
number
has-
2 modified to allow for snow removal.
Yeah.
And Glenn, as your thoughts are welcome.
No, I was just thinking, if you put this restriction on, the proper procedure to handle oil and so forth, in this, you're targeting one particular company. Who's gonna go out to all the other ones and say, oh, you know what, you gotta do this too?
Well, the government does that. There
Right,
are
right, but
regulations in place.
Yeah, well,
For the
outside
safe
of us. so we-
operation, the safe handling, and the
Yeah,
safe
to his-
removal of everything.
To his point, everybody's held to those regulations, but we're now making a special package for this one company and
Don't we
saying,
have building inspectors in business? Don't we have a building department with inspectors that go around and inspect businesses? I mean, we have people who do that in our town.
I mean, I don't.
This is their by right. If you guys are agreeing that it has passed the powers test,
right.
it's by right. We, as property owners, we can't deny them their right. It's their legal right. If you're saying they passed the powers test, it's their right. It's their inherent right as the property
if
owner.
you wanna
as an
change your
A.
oil in your driveway and you claim you do a good job, I can't then come to you and say, we're gonna put special rules on you because, you have an SUV and not a car, so we think you can spill more oil than regular. It's like, well,
But as far as operating their business and how they're doing it and so forth, they have their license, they have their permits.
They do it at their peril, is what they
Right,
do.
I mean, but we can't if they haven't violated the powers test, then by right, they can operate the business they have at the property that they own. I mean,
So as to number 4, I mean, would it just be a matter of they shall maintain the visual buffers and fencing that are currently existing and replace it as necessary?
well, it says they'll maintain it. I mean, I'm assuming that
Right.
means they'll maintain it.
So
I mean, I think maintaining is a
I don't
pretty
think we have
well-defined
to add more
term.
description
Right, I think
other
we
than
can leave it
what's
alone.
currently
I appreciate,
existing.
The discussion, but I don't think it's necessary.
I think it's pretty clear. Maintain what's there.
That sounds like the beginning of a motion.
Oh, wait, I want to take number 5 out too.
I'm fine with that.
Oh, I'm sorry, we're on that.
You wanna?
No, the barn,
Or just
yeah.
number 3.
Yeah, it's very hypothetical.
4.
okay, so we're losing 6, we're losing 5.
No, but
We
4 is
just want
fine
to
the
wipe
way
it
it
and
is.
just not include the restrictions and just.
And then if it
Everything
comes
that's-
back,
That's there is really, except for the 8
I am
employee.
fine
think
doing
number
that,
one
and
is
then if
Well, number
anything's
one is- number
challenged,
one is
we can look
important.
Right,
back and they can
that's
come
got
back to
teeth.
what it
Well,
was
wait a-
when we approved it.
Number 1 is important, number 2 is already apparently covered by town bylaws.
It is.
Number
3 and 4.
They're very subjective. I mean, the site has got a property line that they can't go past the property line, but we can't tell him not to
There's-
put his
there's a
bricks 6 inches
residential
out
and a
further than.
Business, but there's no division per se.
Number 3 is a little bit.
I mean, unless they're saying they're not gonna cut down any more vegetation currently on the property, which we've limited
But if-
we've limited other companies and developers from how much vegetation they can and can't cut down on the property they've developed
That was-
previously.
And we forced them to plant new.
That was like 40 bees.
I'm just saying, it's been a
Glenn's got a
stipulation
question.
before.
Yes, Glenn.
It seems to be the most restrictive on the site is number 1.
Yeah, we all like
What
number
business
1.
can you
caps
do with
everything.
more than 8 employees?
Yeah, I think
Yeah, but if
everyone
you-
is agreement that number one is,
Why don't we make
Unless
that
you
the
turn the-
only condition?
Could you get around it and turn the house into
I mean,
like
I mean,
a
if you
work
goes
bunker?
to 20, I think the
House
intensity of
all
the
your boys
business
there?
would violate the powers test.
Oh, absolutely.
Yeah.
Absolutely.
And
think
have to be
that's-
clearing more land and, doing a lot more things out there.
And a new complaint is gonna be addressed, so that's your protection.
okay, so we'll lose number two, we'll keep number one. Do we care about number, three is very
I don't think we
subjective.
can define three. I don't think
Okay.
that's-
So
you're-
five's out, right? Everyone
Five
agrees
and six
five's
are
out.
out. It's,
Four
it's
is
up
out.
to 1 and 4, I guess, to maintain. We like number one. Is number 4 even useful?
Maintain visual buffers.
think so.
I'm fine keeping that.
Yeah,
Okay.
I like
Okay,
it.
so 1 and 2, which is now 4.
No, we're losing
Two
2.
conditions.
Oh, yeah, 1 and,
And
Being
four.
1 and 4.
we're keeping 1 and 4
Yep.
in this list.
To be known as 1 and 2.
Yes.
now. Okay.
Okay.
Two needs to have something in there about the special hours for snow removal.
No, we're removing
We're
that
gonna
number
remove
2.
entirely.
It's governed by the.
Because it matches the
Bonnie.
town
I
bylaws
don't
for
think the
hours.
town says anything about snow removal hours.
They're gonna turn on a
They're
truck.
gonna be
You
allowed
can't
to-
restrict
They're not
anybody from when they
prohibited
turn on a
by
truck.
plowing.
As long as they know they can't be loading and downloading salt before 7 AM, so they prepare their vehicles the night before, which she says he does. So when you turn on your vehicle at any time, that's for any owner. But if a butter complains that, hey, it's 2 AM and they're down there with their backhoe filling up their trucks with salt, then that's in violation of doing business outside of the 7 AM, which is dictated in the bylaws.
Yeah, no, I think
So,
So he has a good point.
What is the good?
what's that?
the snow removal is not included in the town bylaws.
But it's still
Technically,
conducting
you can work
business.
from 7 AM, I think, till 7 PM, 5 days a week, and then it's Saturday, and there's no
It's the
work on
noise.
Sunday
It's the
technically.
noise, is it, yeah.
But it does not include snow removal, so
So Glenn brings up a good point.
So what is
So
that?
what does
Or
that
it
mean?
is.
Snow removal can be any time at any hour? Like,
So there's no restriction on snow removal operations, basically.
well, I mean, if you're in the middle of a blizzard, there shouldn't be. This is, you know.
yeah, it's a safety thing.
A similar item is a person has a business towing cars. They would be outside the hours in many cases.
Yep, right.
Good point.
And what is the takeaway from that statement? That
I
we-
think
we
we
don't
should
need
ignore it.
number
I just
two.
think we should
Yep.
just say, no more than 8 employees and visual buffers abutting residential property shall be maintained by fencing or evergreen vegetation. And hopefully they'll be a good neighbor and not be running a machinery at 4 in the morning unless absolutely necessary. And, you know, if there's a blizzard, it is necessary. I mean, it's not,
I mean, if there's an issue, they can always seek appropriate relief.
If there's a blizzard, then they won't be doing, well, they'll be leaving the property to go do something elsewhere, right?
right,
It's
right.
not-
They won't be on, that's why I don't think it's really a problem. I
And
think that
plus, I don't think we can tell them that they can't clear their own property, right? You
Right.
can clear your driveway at 4
At
o'clock in the morning if you
without
feel
problem.
like it.
Yeah.
So,
Let's just do 1 and 4 and refer to 4 as 2. So there are 2
Actually, I think it says.
2 conditions, no more than 8 non-resident employees, and business, visual buffers abutting to the residential properties shall be maintained by fencing or evergreen vegetation.
I would like to throw caution to the wind and make a motion.
Whoa.
Stop the presses. Stop the presses.
That's for the application for 150 to 1-152 Dalton Road, for Luc Fougere, DBA Fougere Landscaping, Inc., and 150-152 Dalton Road, based on the application of the powers test. We will overturn the building inspector's denial, and state that this operation, this business can continue to operate as long as it has no more than 8 non-resident employees and maintains visual buffers to abutting residential properties with fencing or evergreen vegetation.
Before we vote, does that sound right to you, sir?
Sounds good to me.
Okay.
I would really like to second that, please.
Second by Charlie. All in favor of the 5 voting members?
All right,
It's unanimous.
Unanimous, all right.
good luck with it.
Thank you all for your patience, your time. We certainly tried as best we can to. make this work for all.
I'm not even joking.
Thank you so much for your time, too. Thank you, seriously. Thank you.
You're welcome. Have a good night.
Continue, Phil.
I'd like to make a little, like, not a motion, but a suggestion.
How about a story? You got a
Could
story?
we?
He did say he had a story.
Stories, because they don't like them. Could we do the floor area ratio and 195.9 and 195.8 on our next meeting on the 9th?
I don't think we can because
Oh.
Could we put that on the agenda for the 9th
it's just gonna
instead?
be before.
Because of the late hour?
I feel like the planning.
I have another, Chairman, I'd like to make another suggestion.
Sorry, I didn't hear any of that. For the 9th, what was the question?
Well, I know, but I just.
I think
Thank
he
you
wants to
guys
know
so
if we
much.
can do the
welcome.
thing with Evan at the next meeting instead of staying tonight to discuss
The 8th
it.
is the planning board.
The
The
9th.
9th, we have a special meeting on the 9th.
But the 8th is the planning
Board
board.
is meeting on the 8th, and for
So we have
purposes
to
of
have a decision
finalizing the
before.
language in order to get it on the warrant.
So that
We have
Brian
to
can
do
go
it.
in on the 8th.
Okay, you're right, so we
on
have to
the
do that tonight.
Yes.
I know it's late, but I think that if we're gonna do it, we should
If
do
we-
it
Right.
tonight.
You're
Yeah,
right,
and then
I
Brian will
forgot.
have something to go in with on the
I
8th.
forgot it was
I
you.
personally think that if you
Brian.
just say, okay, well, that's what the
Brian.
planning board would like, Nancy's gonna beat me to death.
I really think it's only the second half. I
Before we-
think that
before we-
for 195.8,
time out,
I feel
time
like
out.
they were fine. So I was there. and I
Before we get to
listened.
that, there's other
Can we just
hearings that we
close out-
have
hold
to
on.
like
Continue.
continue or something.
Yes.
Correct, yeah.
Can we please just- Here we go. All right, so the next is 16 Freeman.
On 16 Freeman Road, Jeff Hansel has a request to withdraw the application without prejudice. I'll need a motion for that.
The
I
motion.
second the motion.
I don't make the motion.
All in favor?
Aye.
Amy.
You're not voting
Okay.
And then we have at 11 Rainbow Avenue, Sarah and Gary Brown are requesting for a continuation of the hearing with no discussion and no date. I guess that would make a
That would
motion.
be for the next meeting.
Continue 11
March,
Rainbow.
not the 9th, March 2nd, 2023.
Make a
They did
motion.
request for March.
March 11, Rainbow, March.
Second.
March 2nd.
Yes.
Jamie, and who seconded?
Oh, sure, I will.
All in favor?
Aye.
Rainbow, thank you.
And we have meeting minutes that we will put off till at least the 9th, how's that?
Yes.
Speed
That's
things up a
fine.
little.
Now back.
Okay.
So what if we approach this simply with single-family homes, we can do it at our purview with the 3 proofs, and two-family homes, we can just do 20%.
I like it.
We'll see where it falls.
I don't
love it.
honestly, I
What about that one on Third Ave, though? That house,
Was that more than 20%?
yes.
Did it
that's-
need more than 20%?
Yes, it did.
Was it
But
30?
it's not like a
It was less than
all-out
30 though, wasn't it?
denial. It's just not as.
Can we have the purview up to 30%?
but only for single family homes?
We
And does
have
that
the
mean that
purview.
No, multifamily.
On multi.
Single family is no limit, it's our purview, and then,
Up to
and then
30%.
multifamily up
We
to.
s- 30.
And that means
still have
we
some
review it
multi-lots.
under special permit, right, to.
Right, and
But
we
what is the
decided,
At that
impact
point-
of that for multifamily? If you, up to 30%,
They would get the special permit, but it gives us the authority to give
I
it
think
on
they're
a
worried
case
about
by
someone coming
case.
into an RC district, which is the only place it can happen,
Yep.
and making 2 families just huge.
Mansions.
But we'd still have the right to deny based on the 3
but it would be a
proofs that we
special
have in
permit.
place.
Yeah.
It would be a special permit.
Permit, not
So it's easier.
Right.
Would it be a variance or a special permit?
special
Special
permit.
No,
That's what we're going
I
for.
feel
Right
like
now,
it-
it's a variance.
I wouldn't mind making it easier to issue the special permit for single family.
It's unlimited. for
That's-
single-
Yeah, and I think that's what you were
Our
saying,
proposal
right?
is unlimited, but we have that purview. We don't have to do it.
Yeah.
And there are 3
I feel like the,
distinct.
and I feel like the planning board might come back and say they'd be more comfortable with us not having the purview to do that for multifamily.
Okay,
But we're
so-
saying multifamily though
30%.
at 30%.
Single family unlimited.
Unlimited, I think unlimited is a lot. Nobody's uncomfortable
When
with
do you think you'll have the
single
decision to
We
Becky?
have that purview of unlimited, not
I
the
know, but
family,
even
the we.
Well, I understand,
Yeah.
I understand,
seem
but I
reasonable?
think that, I don't know, I still feel like that's a lot.
Yep, well, I didn't know if you had
Otherwise
a
now,
deadline that you wanted to
the
work
board
with.
20,
We'll make sure you get a copy as soon as
What's-
it's filed.
It's unlimited now. I mean, when they put it back in, it's
Thank you for
unlimited.
your patience, sir.
Thank you.
That's what it says. It's, right now, there's nothing, because they forgot to put it
Do
in
our
the
best, I know
the
that.
bylaws.
10 of you
Yeah.
with patience.
You have a very nice day.
It's a lot of patience hours.
2 years ago
Oh my gosh.
and I have that in writing from you.
You know, if one person is patient for
So, yeah, so I think that is right here.
He's not very friendly, man.
Because right now,
So you want
the paragraph when they
two-family
insert
be a
it, it
variance
says
still?
unlimited for single family, right?
Correct.
There is no
that's-
restriction.
We,
Yeah.
you were not here.
No, I saw
We
it.
chose that language.
Yeah, so I think the 30%, because I'm pretty sure that one house, because he came back like 3 times.
Right.
And then he ended up totally slicing his garages in
Right,
half.
right.
Yeah, he
Because he
removed,
wanted to extend the kitchens.
And he moved the garage off the property line,
Yep.
it was that house.
Yep. And all because he wanted to make a
make that
bigger home
work.
for his daughter. He wanted his daughter to live
Right.
next door to him with his
Right.
grandson.
Right.
the cause was grand. It just, we
Yeah,
couldn't do
we
it with
couldn't
the
do it.
variance.
Yeah, and
Right,
I
so
think
the
But the special permit
special
will allow
permit
us
with
to
30%,
grant things
I
like
think.
that.
So I'm gonna go to the planning board with 100%, unlimited with our
single family.
proofs, and then with a 2-family, we would, or multifamily, I guess would be even better, would be 30%.
Right.
Right now
I
it's
guess we're,
20.
that's fair.
No, it's, well, on the lot
No,
coverage.
because
but
the
it's-
FAR
so right
area and the
now,
lot ratio is
yes.
0.
Yeah.
If
Yeah.
there's 0 for
It's-
far and lot
You can
coverage.
still get it with a variance, though. You can still approach this and get a variance.
Yeah, but you're
Hard to
not
get a
gonna get
variance.
it to this board.
But it's so hard to
Like
get a
variance.
variance.
I know, so it allows us to issue a special permit, but that's more lenience for multifamilies, for if you,
But we don't have
which
to
is the
give it.
perspective.
But we don't have to
give it.
We
But
can
we're not
deny it.
obligated
But we're more
to.
likely to, and they're more likely to be able to convince us to, which I think is gonna
That's-
be, is
That's
a
an argument, but
concern.
it's.
Even for single family, do we need unlimited? Like, is 100, like, is
I mean, I
doubling
have
the
no problem
house
with single
enough,
family,
or?
it's the multifamily,
Well,
I think that it's gonna
sometimes
be a
it
point
is
of,
a-
it's gonna be a point of contention with the
Right.
planning
That's
board
why they're
also.
gonna come.
Yeah, I'm
It's true,
just,
because look at Pilgrim. Look at the Pilgrim house.
The
And I
mini
can tell you,
mansion?
like, all the
Yes,
planning
on
board's
off
questions,
Old West
Straight
Pilgrim
mansion.
Road. Of course,
all the questions
the
that the
FAR
planning
on that
board
is
had
less
last
than
week were
30, isn't
basically
it?
about how does
Believe it or
this
not, the
apply
FAR
to
on that is less than
multifamilies,
30.
and what
Wow.
are they
Got a
gonna
big
then
lot.
be able to do?
Is-
They get an acre and a half or more.
Yeah.
Right.
That
Does
lot
it
is-
meet front setback?
The setbacks, it's, the
Yes.
the
The one on the
18,
corner there?
17%, 17%.
Because they kept the footprint of the original house.
Yep.
Okay.
They kept the main,
They
but
kept
it
the main
looks
house.
huge.
Wow.
Added to it.
That has more to do with square footage than FAR, though,
I think we
unfortunately.
can always find a case where whatever we're doing won't fit everything.
Exactly.
So, I mean, we can certainly point out like places where 100% doesn't make it work, but I think it'll make it a lot better. I mean, I don't necessarily want to have the capability to tell someone you can make your house 400% larger. Like, I don't want a no limit situation, in my opinion.
Why don't we just do, I mean, we
If
cut
I
it
may-
half.
would have the-
If I may
we could
remind
say
you,
no.
one of the
Yeah.
reasons why you had considered doing case-by-case basis on non-conforming lots was because they vary so much in how small they are
Yep.
in the RB district.
Right.
And so we had a case before us where they wanted the in-law apartment,
Right.
and that exceeded the lot coverage
Right.
in the FAR by just
That
a
was
tiny bit.
Rainbow.
And if, Rainbow, which is
Yeah.
still open.
Yeah.
In that case, not having a threshold gave you the ability to look at it on case-by-case basis as to how close are you encroaching or what exactly is the lot size. That was one of the reasons when the board started talking about it. They decided that the not having a threshold were for those, the 80% of houses in the RB district that are non-conforming in lot size.
So the unlimited is just,
Really, it was
it's
for
for
that.
us to not have a threshold, so when we have the smaller lots, we won't get hamstrung on those, when they're at,
Yeah.
when
Third
they
Ave.
have
We-
15,000
If we did
square
30%,
feet.
I don't
Yeah.
think we would have made it.
Yeah,
Yeah, 30% won't make it on that one. I think it's just over 31 or
Yeah.
32.
so maybe if
That's
we do
fine.
50 and 30.
We're sorry.
Thank you for your time.
John.
Thank you.
Good seeing y'all.
Thank you.
Very
So,
helpful,
good
incidentally.
evening.
Okay.
Blame Paul.
Leaving no threshold for us, I mean, we'd still have to be reasonable in our own voting
Well, you'd have the
choices.
neighbors, you'd have a whole bunch of host of things you'd have to
Yeah.
consider
There's a lot of
before you-
opposition. You're gonna
Right.
pay attention to that.
Right.
I can see that 30% didn't work, and we had some that were 35, but I'm like, if we can get to 100%, so we could double the size of everybody's house,
Oh, right.
But a second floor does that, right off the bat.
Yeah, that's what it does.
Yeah.
but, okay,
Yeah.
I mean, that's just, for me, I feel like,
And they don't need to come to us for
If the
that.
house is there and it's
Yeah,
on the
they
lot,
do.
I think they
and you
do.
wanna put a
They
second
do.
floor on it, and it's
Second
exactly
floor,
the
same
size of the
footprint?
first floor, it's
Yes.
100%.
Well, yeah, because it's the,
I was before
What's wrong with
most
putting a
of
second floor in
you
now?
several years ago for that reason, because you're increasing the
changed it.
existing house by over 30% addition.
They changed it. They changed it.
That just
Yeah.
changed last
They
year?
changed it.
Okay.
Yeah,
As long as you don't change the footprint, you don't need to come in front of us
It's an
no more.
evolving process,
Yeah, they
and the
changed it.
zoning
You
is
can add a
evolving.
second foot and double your square footage by adding a second story, and you don't have to come see us, as long as you don't
And
change your
Not even a
footprint.
foot farther on the offsets, if you put a second floor in, it's
Yeah.
100%.
100%.
Okay.
For me, I'm thinking not just about myself, but also about what future boards might do.
Yeah, yeah.
And
Yeah.
if you give people no limit,
How about we do 50? Cut it in half.
Yeah,
50 for
I
single
agree.
family,
That's
30
not, it's
for.
not just about
The
like our
100% is
personal
just simply a second floor. If you have a
tendencies.
small lawn and you have a single floor on it and you want to go up, you can.
No, well, but we're talking about FAR and ground coverage, not house. We're not talking about house.
Floor area
We're not-
ratio
floor- yeah,
doubles
yeah.
when you go up.
Yeah, but I'm saying.
If
but-
you go up by the same size as your
Right.
footprint.
Yeah.
Doubles, 100%.
So are
No, I
we
get
essentially
it.
just allowing everybody to add a second
But our
floor on their
50%
house?
would
And is
be
that a
on
problem?
ground
You know what
coverage.
I
As long as you
mean?
follow the
Like,
Our
I don't
land
know.
coverage
Why is that a
ratio.
problem?
restriction.
You can take a ranch and put a second floor on it all day long.
Yep.
No one will
I mean,
stop you.
do we, I don't know.
Nothing, there's nothing
You could do
preventing
3
that right
stories.
now.
Like, maybe you don't think it's, well,
There's nothing stopping anyone from doing it right now without seeing
I've
it.
done it.
I'm
They
okay
pulled that
with
from the
doubles.
bylaws.
Illegal.
So,
They pulled it from the bylaws.
so we had 30% or 20%, and we're trying to go higher,
We
and,
had 0 FAR area.
Yeah.
And 0 for lot coverage.
okay.
So we said, let's go to more, but the floor area creates a problem when you go up on a second floor. I think if your footprint is this big on the lot, what's the difference if it goes up 2 stories? It's inside and the space is a lot, but how does it change
well,
your?
the neighbors might,
Yeah.
I mean, you know,
Setbacks
like
and-
you have
It
neighbors,
does
you're
change
gonna
it.
block their views, you've got
You-
like.
you can do
I
that
mean, it's-
today.
It's still
Yeah,
a
but you
fact.
can do
That's
that
already
without
ongoing,
coming
like
to
Hart
us.
Pond, when people putting their additions on, right?
And you, as long as you don't change your footprint, you don't need to be here.
Yeah.
And it's
So then,
100%.
FIR wouldn't affect that perspective,
Nope.
no.
Could or it couldn't. FAR, it could.
If they don't change your footprint.
With lot coverage.
No,
But
but
lot
the FAR
coverage,
will,
the
because
biggest part
it
is.
will,
is-
right?
It will, the FAR will. Going up on the second floor will change the FAR.
It will change the FAR,
And for
right?
some, they won't have to come before you, say their basement is unfinished. So maybe going up wouldn't make a difference on that number, but for others where they already have a finished basement,
Are
then
you
perhaps
sure?
not,
I
because I
thought-
believe that's included.
I thought the new book, the FAR, they, as long as they didn't change the footprint, they didn't have to come in front of us when they
It's
did the
floor area
revision.
ratio.
Floor area
That's what
ratio.
that does. It has nothing to do with anything else.
Yeah. I didn't bring my book.
Sure.
So, the change of the floor area ratio doesn't
Where was
change
it,
the lot
190?
coverage. You're getting,
If you
going
go
up
up,
does not
the
change lot
coverage
coverage,
does not
but it
change at all.
changes the FAR.
Right.
One
That's why we
ninety.
So
went to-
we're talking about lot coverage, not FAR necessarily, right?
Yeah.
Right.
Nancy wants to go home and go to bed.
It's like, asking questions.
Yeah, right.
She does.
Shut up, Peter.
So, let's see, so the 3 questions Evan asked, going back to his questions. Yeah, implications, and then making this distinguish between single and 2 families, because one member in particular was concerned with 2 families having too much leeway.
What is the difference between floor area ratio and lot coverage is clearly how much
Ground
the
space.
ratio of
Including
your,
both floors.
Not,
No, lot
no.
coverage is the percentage of the rooftop, including garages and sheds, how much your lot is covered.
How much
That's
is
the
the ground?
That's
by
the footprint.
ground.
yes, the footprint of all your structures.
Everything with the roof
With the
on it,
roof.
yes,
Okay.
That's
then-
lot coverage.
Yeah.
that's lot coverage.
And the
Whereas-
floor area ratio is,
The ratio of all the
Square
floors,
footage.
first and second floor.
Square footage,
Basically
basically.
divided by the square footage of the lot.
Yeah, it's like the square footage of the
Percentage
house,
is
to
adding
the square
to it.
footage of the lot. So that's where the different floors comes into,
and
yeah.
do we feel like we need to be able to more than double that in a given?
We feel that we can, not that we
Yeah,
need to,
but
we
that-
have to.
That we would like to have the ability to more than double
Where
that.
is that in here? Where's that?
Like for me, I
Do we
feel like
want
that's.
that? Because that is that gonna open up like a, I don't know,
I mean,
seems like a lot. It seems like a big jump.
to go from,
We're
to go
asking for
from,
like,
people
we're
to
asking
come
for like
seek
free
relief.
reign, you know what I mean? Like,
to go from 20% to no limit is.
do we wanna give ourselves that kind of
Yeah.
power? Really? Do we? Like, do we wanna
But
give
you're not
ourselves
going
that
from
kind of power?
What's the far,
Basing
I
the
don't.
plans.
what can we do today?
I don't ever wanna put anything in here.
Is the percentages in there?
Which one lets you go home? and-
Oil leaks into the
Insufficient. It's not in there, that's what I'm
Well, you know
saying.
what?
Other
I
dimensions
remember-
to work.
listen, I remember
I just don't
like
wanna have
a few years
subsection
ago,
E1,
that
you can
North
have
Fire Station.
building
North
height
Fire
and
Station
far
was
requirements.
Put something on top of
Where
the
is
garage,
that?
and it's like, you know, you're at
Where is
100.
the far
requirements
requirements?
and stuff, and now you know what
Yeah.
they're doing up there?
Right.
PFAS remediation.
So
Yeah.
like most of the houses are in RB.
Well, they should've done.
This is what happens, like you kind of go,
Permit
okay, I
not
guess
to
it's
exceed
okay.
15%
And
of the
years
square
later,
footage
you're like,
allowed in
Yep.
subsection
You know, like,
E2.
If you didn't pick up on what they were saying,
area
then
ratio
and
is
knew that
15.
was coming.
I did.
Yeah, oh, I
Well,
did
and I
too.
was like, I'm
So-
really
I'm looking
uncomfortable,
at
like,
it
like
right
I
now.
said,
Go
I was like, I'm
15
really
and
uncomfortable
20.
with this.
15
I
and
said
20.
to him,
But, you
the
know,
salary
it's
So I'm
was
like, to go from where we are to like 5 times that, more than, like, I'm like, if we increase by 4 or 5x, we are opening up a lot of possibilities.
Here we go.
But that's
I don't necessarily
Yard,
want
used that way.
capability to fix
Frontage,
every possible thing out
yard.
there, because, you know,
Minimum yard
Then we might-
requirement.
do more than we need to with the other ones, because, yeah, we can.
Floor
so,
area
yeah, like,
ratio, here we go.
Go up 165%, why not, you know, because.
But just changing it to a special permit by itself will allow things like the rainbow or stuff like that, right?
Yep, it's
We're not talking about the
commercial.
dimensional encroachment.
You still
on
gotta
the
be
property line.
12 or 15 or 25
The
from
setbacks,
side.
Right.
yeah.
And that triggers its own special permit for 20%.
I
or
mean,
variance.
11 Rainbow is a perfect example of
It really
why we're
is.
looking at this,
Yeah.
because it's
That's what
a,
started the whole thing.
Yeah.
I think they went to what, 35%?
yeah, and it
Yeah.
was, and you know, it's
I
for a
can bring
good,
up Rainbow.
a good thing. I mean, that's where your governance or our governance
What
says,
page are you
hey,
on?
look, no, we're not doing this just because you want a giant
Yeah.
TV
Attachment
room or
to,
whatever it is. You know, you're looking at it from a standpoint
195
of,
attachment, 2.2.
But
it's
what do-
important to a family, and why would you try to dislodge that family out of the
Well, but
town?
also like allowing homeowners to do reasonable things with their property, right? Which is like,
So
Yeah,
that if it
tab.
comes
Here we go.
before us, then we
It's
have
like the
that
one in the
discretion,
Westlands too.
but-
I mean, that was just such common sense. All the neighborhood was crying up. The woman was crying.
So this says
you
what
know.
the minimum is, but it doesn't say where we can go.
But for Rainbow, what do we would need 35% to fix that, right?
Yeah,
Was it that?
I think it was 31.
So, yeah,
So
if they
I think
exceed
35 would
this,
be
then
the-
Yeah, so,
we can't.
so what I'm
have
saying
a
is, if we
variance.
go all the way up to a ceiling of 100%, we could fix Rainbow, we could have given them another 2 bedrooms
December.
or whatever. So I'm okay with going past the 30%, past 50%, I just don't wanna have no limit, you
but
know, I
then
don't.
do you want to have them coming to you, to us saying, we want the 2 bedrooms and the garage and everything else, and then us having to really make decisions about whether we want to, that kind of expansion?
It'll
Do
be
you know
more
what I mean? Whether-
applications, it wouldn't necessarily be
this is the one
granted.
that's-
Yeah, like, then do you want people to be like, oh, there's no limit, we could just add on like all this extra space because it's totally just a special
Then your
permit,
tax
it's
base goes up.
easy.
Addition,
I mean,
There is the
existing
financial
dwelling,
side.
building coverage, this was
You know
covered,
what I
so they
mean?
would
Small
go
little
19,
Like, is
they
it
were
gonna
only
open up
allowed
the
15
floodgates to,
for building
Yeah, the financial piece of it, right. Building stuff now is so
The
expensive.
FAR.
So that's
They
another thing. I
won't
mean,
mention
you know,
it.
if you're
That-
talking
that's-
about a
that's the
builder,
max, but
okay,
they don't
he's
actually
trying to
top
make
it.
a
Well, there's
house.
builders, I mean,
So that-
builders
yeah,
come in
it's
front of
not
us
in
too,
here.
you know,
Oh,
so
that's
that's
what
the
it
other
is.
thing.
So
We're not
what
just
is the-
talking
what
about
does
like
the
Joe Schmo at
paragraph
11 Rainbow
say?
Ave who
Where's
wants
the
to like,
paper?
add a garage on, like, we're talking about
Joe
everybody.
Take offense to that.
Everybody, like, there's builders that come in front of us, there's, you
And
know,
finished
Jose-
basements count too.
Finished basements count for the FAR. So I pulled up 11 Rainbow, if you wanted to see where that's at.
This is the
there's
one that
also
started all
like,
the
so
confusion.
somebody mentioned, you know, this, and I've seen this actually a little bit, like this,
The work to
you know, like
structure that
across
will
from
remain
Center
within
School
its
where they put
existing,
the
which
2 houses
complies.
on the lot.
Oh, yeah.
So then do we come into this situation where developers take a lot and put 2 houses on it?
That's what they're doing all the
Because
time.
the FAR is
Yeah, they're gonna
100%.
Well, no,
If there's
because.
No,
no
because you
limit,
need a
like-
minimum.
You can't have 2 single-family homes on one lot, that's against the
I
bylaw.
mean, do they
Five.
connect? I don't know. Do you know, are there ways around it? Like, these are
it's a
questions that the
two-family,
planning board was
right?
asking
Yeah,
the
it's
other
a
night, and I was like,
two-family.
I don't know.
Yes.
Those are 2
That's
families on
considered
RC
two-family,
lots.
yeah.
They're 20,000.
The ones across from.
That are
Well,
two-family.
pretty sure.
Yeah, so across from the center school?
Yeah, no, you're talking
Oh,
about the
you
2
have the
families.
old drawings.
I'm talking about next to the
got the
new,
old book?
the newly built 2 families, what you're talking about. Next to that,
Street.
there's 2 houses that they basically, like, I think
Why
they
does
like
it say
condoize them.
2019?
Yeah, they
And
tore
put
down a
them-
single family and put a
Yeah, they
So
put two up.
I was thinking of that when the planning board was
Why
asking
did
about
pages say
multifamilies and like an
2019?
unlimited FIR. I was
No.
thinking about that, and I was like, would that
The
open
front
up
page
the
says
door for that, for them
2021, but the
basically being
page
like,
He
in
didn't
it
have
says
to even come in,
2019.
right?
Yeah,
He-
that's
he
two
didn't come in.
structures on it.
2004.
So, you know, like, is
Yeah, but
that
that's
like?
under the existing law,
2015,
you know what I mean? It's
Why are
already-
they all
But if
page
we
dated
increase
I think when those
the
parts were added
FAR
in.
to unlimited, are we gonna see more
That's
of
the date that
Do you know what I
those-
mean? Are we gonna
that
see more
certain
developers
amendments were
asking
made
us
on
for
certain
special
sections.
permits for that? And what are our grounds for denying them? Do you know what, if
Well, I
we
don't think
increase
they
it to
can put
no
another
limit, what are our
structure on
grounds
it.
for denying? Like,
Well,
I
look what
mean,
the
just
40B
we don't like
stuff
it,
has
or the
done.
neighbors don't like it, like.
What the 40B stuff has done.
But our grounds for denying special permits
They come in and say
are-
40B, oh, okay.
Like, our grounds for denying special permits are less so with a variance, like, we can deny a variance
Because
for
the
a lot
lot
of
is
reasons,
that much
right? And not have people have grounds to
And a
come
minimum
back and sue us
non-use.
and
All
like,
right.
with a special permit,
Right.
if we're just denying
And
special
they
permits
come
to
down, but it
developers
doesn't
left
add
and
up
right,
to the
doesn't
same.
have
It
to be
doesn't,
our towns. We also
doesn't
don't
shrink.
want them
this-
to have the grounds to
oh,
come back and
here
be
it
like, you
is.
had no grounds to deny it, you know?
Following-
So unlimited
Yeah.
just is a little.
No, I get that aspect that you're trying to
Existing
protect
to
the
the
town
work
from
provides us
litigation, yeah.
some protection
Read
to
one
not
of them,
have
and
it
then
be
you'll be fine.
limited, right?
Well, then a lot more thought needs to go into this.
So this
if you
meant
ask me.
that they had
If
to
you- if
come
you're
in
really
for a
getting that
special
detailed
permit
with it.
if it exceeded
Yeah, well,
this,
but
right?
those, see, these are the questions that the planning board was asking when I was there last
This
week,
was
and I
the
was like,
old
I'm
one,
glad that I
right?
didn't offer to
then
stand
they
up there and
deleted
answer
it.
all of this, because like, when we got to that
Then they
point, I
got
was
rid
like,
of
this is
this.
well beyond, like, my,
Existing footprint to
I
work.
don't even know where you
with-
got that. Did you get that
by
from Charlie?
myself.
No, that was in the meeting notes, one of the handy notes. You should have this too.
Evan first came in to talk to you and showed you the part that was inadvertently taken out of the old bylaw. I believe that's
so
the
he's
page
got
of
it in
the
the
old
other-
bylaw.
This is the old
Of
bylaw.
the historical homes.
So before,
You know, a lot of
if
stuff.
they exceeded their
I mean, if you
increased
change the
more than
bylaw,
30%, they had to come see us. They deleted
A
this.
lot of it's from.
They eliminated this.
They wanted
As
to-
long as they were in the existing footprint, they deleted this paragraph. Actually, they deleted this one too, it looks like. I can't see this one
Leave it
either.
then, sit next to
How
Nancy.
would it
'cause
have
she knows
changed,
it all.
would it have changed, Second Ave,
It's
for
helpful.
instance?
To
if
work
you
to
had
a structure which
unlimited-
encroaches upon
Third
one or
Ave,
more
whatever.
required
No, no,
yard
no, no, no,
setbacks
remember
where,
the-
yeah.
He
they
wanted to put four
really don't.
houses, we said
Oh,
no.
that nightmare, yeah,
But
yeah,
paragraph
yeah.
Well, that'd be a special permit at that point, right? He could come in for a
Special
special permit?
permits for non-conforming single and two-family residentials in the event that the inspector
No,
deems
if
that
we,
the
if you
non-conforming.
changed it. So if you changed the bylaw and we said, okay, it's unlimited, right, but you had to come in on a special permit.
But this is gonna not allow multiple structures on any lot.
Okay.
Still, it
Multiple
doesn't change the multiple structures on one lot.
Primary residences. You could have a multiple structure.
Where he was
shed garage.
pre-existing, you know, the whole thing, right? Pre-existing, non-conforming.
There it is.
Like a loophole.
Okay,
How
so
many loopholes are we gonna create? That's
you
my-
could
yeah.
create loopholes doing that, because that was part of it, right? The FAR was part of it, and
Yeah.
So if we
Look at
unlimit
that.
it, you open.
According to the new
Are
bylaws,
there
we
that
were in
many
a
situations like that though?
Because the
You
paragraph
gotta
was
think
deleted.
about
shit show.
I think it's a
Well,
rare,
Yeah.
rare occasion that happens, but.
If we turn it around, does anyone have a reason why we need unlimited? Like, we bring up different cases of rainbow and that,
Right.
we needed 35, we didn't need unlimited.
right.
Is there any reason why there is not a threshold that would fix 99% of the stuff that comes through here?
No, right.
And I mean, what is that number? Is it
Right.
50%?
Number,
Is-
that's
Paragraph gives us the authority
Is
to
the
give.
created, the
But it's
Board
not
of Appeals
unlimited.
made by special
What allows
permit.
us to, well,
Allow
yeah.
such reconstruction, extension, alteration, or change.
Yeah.
Where
Yeah,
What
your
lets us-
point,
what
Steve,
lets
is,
us add the
yeah,
garage
it's not,
modification,
doesn't
but
need to be
not like-
unlimited.
Not
It really
substantially
doesn't.
more
Especially when you start
detrimental
thinking about
the existing
the
non-conforming
structures
structures.
and
in it.
properties and that
That paragraph
existing.
gives us the authority to issue a
And the
special permit
complexity of the.
that exceeds
And if so, there's no FAR there,
C.
he's, hey, we can put up a
Dimension
condo
requirements.
complex.
Developers
Any of
have
the
lawyers,
dimension
they're gonna come in
requirements.
front of us and they're
These are
gonna
not
make really
dimension
good
requirements.
arguments.
FAR
you know?
and
I mean, it's
flood
the
area
things
is
that the
dimension.
neighbors
Far
might hate,
specific.
and
This
I
is
don't
just
know, like,
dimension
it just
requirements
I
seems
would
Yeah,
hate to do
based
that
on
to a
the-
neighbor, that
where
where
it
you
was
couldn't stop
positioned
him
in
at
the-
that,
right.
that would be terrible.
So,
That's not
Yeah,
far,
so you
far
don't
as on the
wanna
next
create
page.
laws that
if we say
allow-
our worst-case thing before was
The authority
rainbow,
for us
that
to
was
actually
a
give the
31%, and if we had
special
40, it would have fixed it. Is 40 a good limit?
Because
Is
far is
50 a
the
good
next,
limit? But I
this
don't
has
think
nothing to do with far.
going-
Above 50 is probably excessive.
Yeah.
Okay,
Yeah, I kind of agree
you got
with
that. Are we doing 50 and 30? We're doing 50 and 30, is that what we agreed on? 50
50 for
For
the,
single
single
families?
and 30 for,
Yeah,
yes.
that's what we just agreed.
I'm okay with that.
Yeah.
50 and 30, 50 single, 30?
Everyone still seems.
Does anybody have any thought on impact of thirty
Opens the,
Yeah,
for
oh, yeah.
multi?
Be a shit show.
someone could make that one.
Right, yeah.
Have all the whole book.
Even 50's a lot, right,
Because
when you
of-
think about it. It's like
Yeah,
you
but
said,
the-
we haven't run into
Facing
that.
far,
50 should
Pre-existing
be enough.
multi, or is it for future multifamily?
non-conforming.
But wait, Rainbow was a multifamily,
Was it?
right?
No.
Well, when you put in, I was gonna ask
it
that,
is
when you put an LAA on, right, an LLA or whatever, is it considered a multifamily?
That's still a
at that
single
point?
family.
No.
Okay, so that was what it was.
LA.
That was
LA
it,
is
yeah.
multifamily.
Okay, so 50 and 30 sounds like we're all in relative agreement?
Yeah. Glenn, right? You
50 and
said,
30?
Yeah.
No.
You're
50
still
and
like.
30?
I mean, I think, I would agree, it's better than, I think unlimited is.
Yeah.
50 and 30.
It's not a good idea,
That's
so,
what I'm
yeah, I
saying.
mean, 50 and 30 sounds
Right,
reasonable to
right.
me.
Shouldn't be a lawyer.
I'm sure there's
It's a
still
good
like,
argument.
You feel that covers the second floor, though?
I almost
We
went
don't
to
have to
law
worry about
school, I
second
think that
floor.
was a-
We're talking about far. Or, we're talking about
Yeah, we do.
ground.
So,
That's,
Floor area ratio does include the second floor. It's the floor area.
Yeah, but they can do second floor, as long as they don't change their footprint. They could do 100% without coming to us at all. They removed that from the, they purposely removed that in this in this new bylaw. What's missing is ground area ratio, which is what's been getting us.
The lot coverage.
Yes, lot coverage. That's what we need to be discussing.
Oh, so that's
Far.
the 50-30, it's not
Yes,
far, it's
not
the lot
far.
coverage is the
Yeah.
50-30, that's what we're.
FAR is still in here if they're exceeding, if they're changing their footprint. FAR is still in here. Lot coverage is what got removed, which is what we need to determine.
And then, weren't we discussing like lot size at all too?
yeah, well,
With
that was, I
That
was just gonna
impact.
mention. So,
This,
you know,
this one that created the problem was 11 Rainbow Ave.
And the lot-
Existing dwelling is 1,550 feet on a, actually, how big the lot is? It would be considered a 40,000 square foot lot. This lot is 10,700 feet. The existing dwelling is 1,500 square feet, not a big dwelling. They wanted to add a proposed addition of 504 square feet. The building coverage went to 19.1%, which they're allowed 15%. So they're 4% off on that. And they can't do it without a variance, and variances are tough.
Yeah.
So it was the
At
building
19%,
coverage,
but if we
yeah.
if we were at 50, they'd be able to get it.
Oh, if we were at 50, they'd be more than double able to get it, so maybe even 50 is a lot.
You're still
they needed was
limited by
20.
the setbacks that are.
yeah, but you're limited by setbacks, I was just
Setbacks.
And
gonna
we
say that.
still
and
have
stuff like
control
that.
over it. We don't
Right.
have to grant a
We're
special
limited.
permit.
Yeah.
If we go, that's ridiculous.
We have a
It's ridiculous.
threshold.
It just gives us a little more.
We have the
I
threshold of
don't
50.
disagree that, you know, like,
Because
oh,
that
well,
other
he
house
did
would
it,
needed
you know.
more than 50,
but-
and they still would have made setbacks, but they needed more than 50.
So are you suggesting still having it by special permit, but with the threshold?
Our
Yes.
threshold
Like
of
you can
authority would
still-
be 50 and 30.
50
like
for
50
single, 30 for two-family.
For a special permit.
For-
And
but
anything
With a
special
over
permit
that.
instead of
After that, it's a
variances.
variance.
Yeah.
Okay, but right now, it is, what, 20% or
Yeah. Well, it depends on what,
Ground for,
15
15?
for lot coverage
in an RB.
and
in
it's,
RB,
and it's variance.
which is where you're running into most of the problems.
Right, we're
It's
not gonna
RB.
see it in RC, because that's a
And
two-family.
Rainbow was, for coverage, it was what?
Building coverage was
Well-
1,550 square feet, which is 14.4%. The proposed addition brought it up another 4.7%, to a total of 19.1%.
Okay, so do we even need more than 25%?
Well,
But that,
so to go back to Sylvan Ave, I think they were at 30, was it 32%?
And we were in favor of doing it, we just couldn't figure out a way
It was
to
such
do
a
it
small
without a
addition.
variance.
Because their
Instead of
garage, the
moving-
garage was.
Rather than
big.
50.
Moving
And the lot-
one
and the
garage
lot
bay
was
from each
so-
side of the house.
No, it's a different house.
the threshold is our
That's not
threshold. We
Sylvan.
still have the discretion to
Sylvan's
look
the
at
one where
all
they
the
just wanted
other
a little bump out to add in
parameters.
an
Size,
office. They
neighborhood,
both work from
abutters,
home with a bedroom
setbacks,
up top, 'cause they had just had
the
another
reason
baby.
for the addition, I mean,
They were at, I think, 31 or 32 with their proposal.
All right, that's
Because
what they
that
did.
lot
They
was
moved
even
it
smaller.
back.
That was a 7,000 square foot lot.
yeah.
And it brought them a little over, I think it was 31 or 32%.
Yeah. And they have
And
small
that was a
lots.
tiny lot.
Very
Sylvan.
tiny.
12, so, yeah,
I mean,
bring that
for
up.
me,
Hold
I
on.
feel like variances, I have a hard time just letting variances go. But when it comes to special permits, you know, it's like, it's a special permit you're doing. So if 80% fell under a special permit, and I knew I have done stuff up to 80%, and someone comes in with 62%, it's like, well, that's a lot less than the stuff we did last meeting, so, go with it.
I think, I don't know, I'm comfortable with 50 and 30.
You open a lot more gray area.
I'm fine
decision-making
going down to
stuff,
like
but,
40 too.
I like 40 more than 50, myself.
I do too. I like 40 more than 50.
30, 40?
Well, 40, 30. 40 for single, 30 for
Yes, yeah.
multi.
I guess my question is, why are we restricting, we're restricting this, the multifamily, so we're not having contractors take
Yeah.
advantage?
That was,
Is
that was
why?
basically on
Okay.
advice of the planning board.
Okay.
Yeah, that's a
Yeah,
good
but we're making it
I
smaller.
didn't think about that. I think it's a good point.
I'd be concerned.
Why are
more
we making it
concerned
smaller
about
for multifamily? I mean, the purpose of the multifamily, they would need more ground coverage,
Right.
honestly.
Well, it's not prohibiting anything, it's just.
But why, I mean, why would we be making it smaller?
a
They
hint
would
from the
need
gods.
more, they would need more ground coverage.
We gotta close this, don't we?
2 units now.
Two units.
until we start discussing.
Why don't we do 40 both? Cut you in the middle.
Although multifamily is only allowed in RC, not in RB, correct?
A two-family.
Yeah,
not a
this is, so
multi-family.
that was
But
my thing. I
it's-
was like, they have different requirements, because it's a different,
RC
right?
is the
But
two
remember that,
families.
what
Oh,
street
two families
was,
fall under the same.
what street was
exemption.
the?
The
which-
headache is that we're going to miss Springtown meeting if we don't act on this. So if we don't go on
what
the
was
8th,
What was the?
So can
what
we
was
just
the
do
garage-
something
What was the two
conservative?
garage, two
and
kitchen one?
if we, I mean, we can always.
Do you remember?
Right.
Two
30,
garage,
40,
two
30,
kitchen.
40,
Which,
Yes.
30, 40.
30
I
is,
don't, 30s even seems high.
are you saying 30 for
Two families, 40
family?
for singles.
Yes, I'm good with 30, 40.
I'm good with it, if that's what the
What
majority.
is it now again?
30 for multifamily, or two-family,
It's
40 for
15
single.
Right.
It's 15. It's 15.
15 for an RB, which is where we're running into the problem. RBs do not allow two families.
And RC is
Right.
20.
And RC is 20. So we're going
they're
up 10% for a two-family,
And we're
and we're
doubling.
going up 20% for a single-family. And we still have the right to deny it. We're not held to it.
I was just saying,
Yeah.
we'll do the same.
It's
but
just under
both.
special
I
permit, not
understand, like,
variance.
oh, it's just a special, but we're not. We don't have to build something, we're gonna drive by and go, oh my God, we allowed that? We don't have to do that.
I think
I
doing
mean,
an
we
equal
may still have
40
to
of.
do it.
It's not-
Probably.
Just because the multifamily is going to need more space. I mean, I'm thinking about that two-car, improving the kitchens for that dad who wanted his daughter to live next to him.
But
And
we
they
could have done
needed-
that with less than 40, with less than 30, right?
No, he needed 32. Even when they cut down.
But we're also switching to a special permit, and we were under the
But he coulda
variance
dropped
before, and that's where we
2% off it
missed
and
it. We
made it
couldn't
work.
meet that variance threshold.
He didn't have to drop it.
Tiny,
He didn't have to.
tiny garages. I mean, he.
Well,
and
that was a setback issue though, wasn't it, too?
No, it was ground coverage.
There was a lot of problems
It was
on
lot
that,
coverage.
but it was lot area.
Lot
yeah.
area got him,
Oh, yeah.
because it was
If you go
such a small
30,
lot.
40, and the planning board balks, then where do you go?
The planning board gets to decide, they're gonna present, they just want our
They're
input.
doing it.
If we
So-
do 40-40 and they balk and they go 40-30, then we at least get to where we go.
I don't know if they're gonna
Negotiating
like.
It's
tactic
really not a
101.
decision, we're
As
just
long
gonna
as
make
we
a
do that.
recommendation.
I think the 30-40 is probably, yeah, I think if we go
Let's
more
call it
than
a
that, it's
compromise.
they're gonna balk.
35?
Point, yeah.
What are you
39.
saying?
Really,
Sorry, I was compromising.
I like 30, 40. I mean, I'm not
Yeah,
trying to fix every possible.
30, 40.
I think that's a
30,
reasonable
40,
thing
that's
to throw at the planning
reasonable.
board and see.
Unanimous.
I would just like to make one more recommendation and.
Motion to adjourn.
No, listen. I don't know about you
We're
guys.
gonna have another meeting.
Wait, she has a good.
Valid
may not
point.
show up,
Listen,
I'm running out of
How-
battery.
How many people read all the materials we got emailed today or in the last 24 hours on this
I
case?
did.
I did.
What? Say that
Okay.
A lot of stuff
I will
there.
tell you, I did not have enough time. So I would like to see what provisions we could include or incorporate for these packets that we get, if it's big cases like this. So I
spent a lot of time doing that today. It wasn't
Yeah,
nothing,
I
I
did.
understand.
I sat for like
had
2
the
hours.
I think a
time
lot
today.
of,
I did not.
Wasn't
we
a
don't
bad
get the
time for me.
submissions
That's
from
right,
them,
it would be
and
very
then they
well.
last
But
minute
if we
submit
put out,
and-
if there's a way for us to put out guidance or seek a way to put out guidance, hey, if you're gonna have big cases like this, like
bathroom
48
is.
hours, we can't,
Yeah,
12
but
hours
the
before
what
the
the
board
bathroom-
convenes, getting
I know,
an
I know
8
what
We
page
had the right to
dissertation.
continue this. I think everybody wanted to stick a fork in it, but
Well, and I don't think we wanted to because of this situation,
I don't know
but
if everybody did, because somebody voted to reopen the public.
is there a way for us to do
All right,
that?
I'll make a motion to close this here.
I second that, Nancy.
all in favor?
Is there a way
Have a
for
very
us
good
to
night.
do
We'll see you
that?
on the 9th.
Yeah.
Okay, so the ninth,
If they're
we
open.
just have the